Good morning. Good morning. Just getting set up. Got the fan out here for everybody, and so we don't miss anything. And I knew she wanted to talk to the attorneys first, so. Oh, I thought she'd be doing that in camera, so I thought I'd better start. Oh, just getting the Twitch stream up. Okay. Oh, my. Nope, don't want that. Twitch is always so. Twitch is always so loud when you first go in there. Gaming, everybody's gaming. Okay, let's pop this one out. Oh, I don't even have the YouTube chat up yet. Hold on. Oh. Morning, Maggie. Hold on, let me get Bingo up. Let me get the YouTube chat up and get Bingo up. It's good to see you. Thanks for joining me. We got our fan going full speed there. Somebody said I wish they would dust the fan, but it doesn't ever look dirty to me. I don't know. Maybe I just don't see it. Hello, Armageddon's Fire. Good to see you. Welcome back. We've got nothing yet. Let's see. Where is this? You could probably hear my keyboard. Sorry, guys. Well, I don't want to mute because I don't want to miss anything if they start right away. Or let you all think I'm not here. It's good to have company while I finish setting up. Hey, Jean. Good to grope you. Good morning, love. You can hear I still have my head cold. All that nasty is making my voice sound a little rough, so I apologize. But I'd rather be here than not. Okay, where's that link? Hope everybody's got some coffee. Today, I'm kind of excited. Today's first day at defense. We get to see what's in store. I heard they're bringing us an expert. Supposed to be somebody who does the same thing as Dr. Welcher. We shall see. Although she did say that they were going to talk to each other first, the attorneys and her. So let's see if anybody brings anything to the table. They did not do anything about not having enough evidence to carry on, preponderance of evidence, the usual that we hear. But when she left, Dr. Cannone said, Dr. Judge Cannone said, Miss Little, make sure you give me that before the hour, before we leave. And so I'm thinking that might have been some kind of motion, maybe the one we were thinking they were going to say yesterday. Okay. Yesterday was a short day. Well, after trial, I wasn't doing Karen Reed, but let's just say true crime did not leave me be. because Lori Vallow had 2 hearings. Oh, here they are. In motion.
You are unmuted.
What do you mean, Chris?
Now opening ABC.
Mind if I go get Sure.
Thank you. So I was told council want to see me at Sidebar?
Some things don't ever change. Court begins at 6:12. Sidebar. That's sidebar number 1. I mean, why should it be any different just because it's a defense, right? Morning couch. Howdy, howdy. So sometimes when court ends, I end up in a little bit of trouble out on the socials, because I might have like a little bit of an opinion. And sometimes like the socials, like, well, they're not ready, they can't handle it, or they just feel like a fight, whatever. But yesterday, I actually had a little bit of fun because I found some mutuals who are just gaga over the ties, And Hank Brennan was wearing the most glorious tie yesterday. It was like silver on silver with like this herringbone pattern, but it wasn't like raised or anything. And it was very subtle. It went really well, with his jacket. I'm just saying. So the murderer, it at it again, huh? Well, the murderer under. Okay. Which means Lori Vallow, not Diddy. Oh, yes, she was. She was. I have a video on it, actually, on East Idaho News caught both hearings, the one in the middle of jury, like at the end of jury selection, and the one prior, which allowed jury selection to go forward. I mean, I got to hand it to Maricopa County. They weren't messing around. They weren't delaying. The trial was on the books. They had the hearing right away and addressed their issues. Spoiler alert. Judge Vareski still was there for the for jury selection. You could just imagine how that went. Well, that man. I have so much respect for judges. I really do. What they have to put up with, trying to balance everything. No, somebody's always disappointed in them, but they just have to keep to their mettle, their fortitude, what they believe about law and order, why they do this, their understanding of the law, and they just keep sailing straight. Now, kudos to Judge Vareski. But if you get a chance, check out my video. Because the second hearing, well, I also did a nice praise post to Nate Eaton of East Idaho News, thanking him because of all of his work in bringing all this out, because we get to actually see Lori in true goddess mode. We get to see the real Lori. Like, he was there. He got it all on film. He put it out for everybody. And we get to see the real deal, not just what she wants everybody to see or hear or think. Someone had said they wondered why she did not want cameras in the courtroom, her being such an attention seeker and wanting everything to be always about her. At first, it didn't make any sense, and I kind of agreed with them. All this time I've been wondering about it. So I was thinking about it last night. I think that's it. She didn't want to see when full goddess mode kicks in, and she acts that entitled. Now this one never wants the cameras to go out. This one is addicted. Is addicted to the attention. I kind of feeling for her when it all comes crashing down when this trial's over. What is she going to do? I will bet you she does not leave the limelight, that she will just crave it even more. She'll be out there. She wants people to talk about what she's wearing and, those camera bulbs and those microphones on the stairs every day. I mean, come on. It's not just me, right? You all know she lives for that moment after court every day, right? Yesterday, she wanted it so much, she was out there without her lawyers. Karen Reed left court yesterday without her attorneys. She usually has them flanking her or her parents. Oh, she was alone. She actually acted like she was the one with all the information too. They were asking her about this, how long it was going to take, and they were asking her about witnesses. She literally conducted herself like she was the lawyer for Karen Reed. Karen Reed's the lawyer for Karen Reed. I mean, I don't fault her for wanting to be in control of the situation. It is her life. I would just say, well, it's kind of like a bad look when you're interrupting the attorney when he's on the podium doing what he does. I mean, shouldn't all this happen beforehand? Shouldn't you have your strategies all work? Do you have to direct every second? Seriously, she was actually interrupting Alessi. That's right. Nobody to tell her, come on, Karen, let's go, or no comment. Yep, Jen. Yep. I think I put it in the read room. It was fascinating. What really struck me is no one walked out with her. At least one attorney is always talking with her, chatting with her, either on the way in or the way out. I was running a little late, so I didn't see this morning. I'm just talking about the way out yesterday. I think on the way in, it was actually Alan Jackson, I think, on the way in. That's Diddy Erderer. Oh, just like Ned Flanders would say it. Okay, because she blamed Ned for everything. Okay, so Lori Vallow is the Diddy Erderer. Okay, did I say it right now? It's a long sidebar already. Here we go. Not quite, but it's closer. Okay, so let me try again. It is Diddy, right? Oh, Diddley Erder. Diddley Erder. Okay. Oh, well, there was Miss Little with whatever copies she was supposed to have yesterday before they left. Did not the judge say, can I have them within the hour? Oh, that's not Miss Little, is it? I thought it was. I don't know. We have the Reed family and the O'Keefe family, all patient. Here they come.
We'll start with the required finding argument.
Oh. Okay. So there is an argument. Here we go.
So I'll hear you whenever you're ready, Mr. Jackson.
Thank you, Your Honor.
Sure.
Thank you, Your Honor. We filed this morning a motion for required finding of not guilty under Massachusetts Rule of Criminal Procedure 25A. I think that's before the court. My comments will be relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds or next couple of minutes are equally important. It comes down to the following. The Commonwealth has simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. There was no collision proven to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form of physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022. The Commonwealth, through suspect experts based on circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date. The Commonwealth also put on an expert who said that she found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scordibello, was arguably their most important witness. The Commonwealth cannot and did not say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence.
Oh.
There is evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview.
Well, I hope you present that.
There is evidence that Brian Higgins was love struck.
Oh, I'd like to see that evidence.
He was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe. Again, there's not a single eyewitness to a collision. There was not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the location at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once. She saw it pull up twice. She saw it pull up a third time. And then she saw it was gone. And at no time did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed. And she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian. Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough, I think the phrase was, to track a cat. That's how detailed she was in her observations, yet she did not see John O'Keefe hit by an SUV. She did not see John O'Keefe's body in the snow, in the yard, laying prostrate, a 216-pound, 6'1" man in the snow, directly in front of the SUV she was tracking the entire time. There are two other witnesses, Ryan Nagel, Heather Maxson. They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe was not in the vehicle when they were behind it. The dome light was on. They could see inside the interior of the vehicle. Miss Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage. Not one witness that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning. Not one. Not until Karen Reed found Mr. O'Keefe at about 6:03.
That's because
again-
I'm outside.
The Commonwealth's chief medical expert, Dr. Scortibello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body. The only person to have physical access to John O'Keefe testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation. And certainly, as to counts 1 and 3, no evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm John O'Keefe in any way, shape, form, or fashion. Hearken to the video at C.F. McCarthy's. Hearken to the video at the waterfall. Every witness confirmed what our eyes could see. That night, John O'Keefe, Karen Reed were loving, caring,
Frustrating
affectionate.
with the cameras.
There's absolutely no evidence that Karen Reed had an intent to harm John O'Keefe, or that that after the fact, that she intended to leave him for dead, because there was no fact to be after. There was no collision in the first place. The Commonwealth's case, certainly on counts 1 and 3, taken separate from count 2, because of the mens rea associated with counts 1 and 3, fails miserably. The Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst. And their case has failed. No reasonable jury, hearkening back to the standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3. But taking count 1 and 3 aside, those are separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow? The answer is none, 0. No reasonable jury could find Karen Reed guilty. This case never should have been brought in the first place. There are reasons that I won't go into here.
I
The court
agree.
knows those reasons, or
She
knows
should have
our
pled
position
for
on those reasons.
manslaughter.
This was a vindictive prosecution, and I believe that the court is duty-bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts. And certainly taking count 1 and count 3 aside, the court is duty-bound to dismiss those 2 counts. Thank you.
Morning, Mr. Brennan.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication. The reasonable fact finder would find that the defendant was in fact intoxicated. Based on the serum conversion and based on Karen Reed's statements herself, you've heard many, many admissions by the defendant about her level of intoxication, which far surpassed the statutory mandate that she consumed alcohol in a way that would affect her ability to operate safely. Those are just 2 of the cornerstone pieces of intoxication, which are clear, light most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence of collision is abundant. I do not want to go through an entire closing argument or rhetoric, but suffice to say there are taillight fragments from the defendant's own Lexus, from her shattered right taillight, that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour. He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming. It is a public way. Lieutenant Gallagher told us about Fairview as being a public way. And so as to the operating under the influence of alcohol manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter. Regarding second-degree murder, as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions at night after being intoxicated, that conduct was intentional, and any reasonable person could find that her conduct that night created a plain and strong likelihood of death. There is no predicate of intending to kill or even intending to hit. There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells us herself. Through firefighter Becker, they're arguing, they're upset. We see the text messages, evidence of attempted breakup. And we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them, but statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypothesis is about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of calls, but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All of those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
All right, thank you. So the motion is denied as to all three of them.
Well, I could have told you
On
that
the
that
other
was going to
topic that
happen.
we were discussing it sidebar. I don't need to hear argument on that right now, Mr. Yannetti. I'd prefer to get started. I would like you and Mr. Brennan to talk to see about proposal. So are we ready to bring the jury in? I did not ask you at sidebar. Are you ready for this witness, Mr. Brennan?
I'm ready.
Okay, so,
Thank you.
all right, so we'll bring the jury in. That will take 5 minutes, Paul. All right, so we'll take the lease.
All rise, please.
Okay, so defense is going to start with their case. So what we heard this morning was pretty much just like when they say, Your Honor, you need to toss the case because the Commonwealth didn't prove it. In just different wording, Massachusetts law. I posted a bunch of stuff right from Massachusetts law there for you. Well, there you go. Good morning. Thanks for the coffee, Pete. Good morning, Teresa. You're going to be listening with your eyes closed? Well, we heard from Alan Jackson, and boy, he did give it like he knew the camera was on him. He said, hearken. Get the heck out of here. Okay. To me, that was a bit amusing. I know he's got to do what he's got to do. They don't believe that the case was proved. They want to disavow everything. You know, Ian Whiffen, temperatures of the battery of the phone. They want to, ignore all of the sync-up evidence that proves that Karen and John and Alexis were the same place at the same time right before his phones stopped interacting. And they want to throw it in there that, of course, Higgins was so crazy for her. No evidence of that. I mean, we all read the text messages, and, well, he looked like he was drawn into it. As a matter of fact, it was going to happen. She was going to keep at it. Like, why not? He didn't look crazy about her. A text after she ghosts him of, oh, well, really? That's crazy about you? We heard no testimony of anybody saying that he was asking about her, that he was showing up at her house or sending her letters or flowers or no, none of that. Just a text at the end when she ghosted him for a couple of days. He said, oh, well, like they were in the same place and she wouldn't answer. To this day, like I speculate on whether that conversation in the car before John O'Keefe got out to go into 34 Fairview, she says it was about, John, go in and make sure I'm really welcome because I'm not so sure. We saw how everybody interacted with her at the bar. She was fine. She was smiling. Everybody, Jen was happy to see her. She said, Jen, there's some video of Jen McCabe jumping up and down and clapping when they entered, that she was so happy they came. Nothing that happened in either of the bars led anyone to shows that there would be any reason she would wonder why she was welcome. It was more like John said, we're done, Karen. Like, I don't want to do this anymore. You're a pain in the butt, or something similar. Or they had a fight, whatever. They were fighting all day. It was obvious that there was tensions there. And from her own words to Brian Higgins, they were on their way out. Maybe that was the moment that John O'Keefe decided he was out. I wonder if he didn't want her to come inside. I wonder if that's where the anger comes from. Maybe not that they broke up, but maybe like, if you're going to be like that, Karen, just go home. You're too drunk. You're way too drunk. Maybe she's too drunk to drive, though. Like, I don't know if he would send her home because she was too drunk, or even think she was too drunk, since he was very inebriated himself. I mean, that whole crowd has a very different view on what's too drunk. Seriously. They were all quite inebriated. I knew they had to throw in Brian Albert and Ryan Higgins, and we're probably going to hear testimony, about that somewhere along the line. But their first is an expert witness, and it is somewhere on the line of the data coming out of the Lexus or something like that. I had posted it in the library. Somebody put his little CV up and his affidavit. It should be interesting testimony. It's a good, strong start. I'm so glad it's that instead of the Proctor, Texas. Like, I know that Mr. Jackson is really looking forward to that. It's going to be quite the theatrical moment when they bring all those nasty texts back in again. Well, the Commonwealth has filed opposition to those 4 witnesses that want to verify the texts. They were all people from, I guess, the text message chain to prove authenticity. You only need one person to do that. But of course, drama, exclamation point, exclamation point, exclamation point. It's the Alan Jackson style. If he can get 4, he wants 4. So we'll see. We'll see what happens with that. Good morning, Karen. How are you? They're not starting too much later than 9:30 when they thought. Now, they pulled it up there, but she didn't say, okay, now I'm confused because she didn't say sidebar before they pulled it up. They were just waiting for the jury to come in. They were taking a mini break, or she was rather, while they got the jury together. I don't think they said sidebar. Did anybody else hear? I heard her ask the court guard for the jury. She said that would be about 5 minutes, and then it went up to the fan. I could check. Let's see if anybody's got a feed up. Okay. Yeah, she didn't call it. It doesn't say that they called the sidebar. It just said that they're going to start. Defense case will begin in 5 minutes once the jury is here. Whew. I didn't want to start the day miscounting already.
You are unmuted.
All right. Mm.
Hey. All persons have any business before the Honorable Beverly Cannone, Justice of the Norfolk Superior Court, and for the country of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, council. Good morning again, Ms. Reed. Good morning, jurors. Happy Friday. So I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. To follow the instructions and refrain from doing any independent research or investigation into this case. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? As you know, yesterday the Commonwealth rested, and as you know, the defendant has absolutely no burden of proof in this case. Does not have to put on a case, but I hear that you are. So your first witness, please, Mr. Jackson.
Thank you, Your Honor. With the court's permission, we would ask that Matthew Disogra join us.
Okay.
So you're gonna step up, face the clerk, and raise your right hand.
You tell us where the evidence you give to the court and jury in the case down here is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Morning. All right, Mr. Jackson, whenever you're ready.
Thank you. Mr. Disogra, could you please state your full name and spell your last name for the jurors, please?
Sure. Matthew Disogra, last name Disogra.
What do you do for a living, sir?
I am a licensed professional engineer. I practice in the field of accident reconstruction. And within that field, I specialize in analysis, interpretation, and accessing all types of vehicle data.
How are you currently employed?
I'm employed by Delta V Forensic Engineering, which is an engineering firm that specializes in accident reconstruction, all parts of accident reconstruction.
Tell us a little bit more about Delta V. What is it? What kind of company is it? But other than that specialty, what else does it do?
So accident reconstruction is a broad field. There are a lot of subspecialties within that. So accident reconstruction is everything from the initial investigation phases of a crash all the way through testimony, like here today. Some of the specialties within that could be things like biomechanics, could be human factors, and my specialty is data, vehicle data and event data recorders.
Staying on that topic, what is your current title or position with Delta V?
I am the Director of Engineering for our EDR services line.
What does EDR services mean?
So event data recorders. So EDR is a general term we can use to talk about all types of data from all types of vehicles.
And how would you describe your role as the Director of Engineering for EDR services for Delta V?
I wear a couple of different hats. First and foremost, I'm still a practicing engineer. I still conduct investigations. I still perform analyses, and I testify. On top of that, in the director role, I oversee a group. It's not just me doing this kind of work. I have 3 other engineers that work with me, all specializing in EDRs. So I oversee that group and focus on kind of the day-to-day operations as well as the direction we're going. You know, with things like autonomous vehicles coming, the role of data is growing. So we're kind of looking to the future in a lot of those ways.
As a consulting engineer, you've indicated what your specialization is. Do you specialize in motor vehicle accident reconstruction as well as vehicle system analyses?
I began my career at Delta V doing traditional accident reconstruction in the broadest sense. And as I have progressed, I have sort of narrowed myself down and now specialize in that. But I still consider myself an expert in accident reconstruction because ultimately,
No, please finish.
Ultimately, anytime we're doing EDR or data analysis, it is in support of an accident reconstruction.
You talked about event data recorders. Do you also engage in the specialty of advanced data recovery methods? In other words, methods of pulling the data. It's one thing to have it sitting in a car. It's another thing to pull it out and make it useful, correct?
That's right. There are a lot of different ways data can be accessed, all the way from just plugging into a port on a working vehicle, all the way through when a vehicle is catastrophically damaged and even the modules themselves are damaged, accessing the data at the chip level. So no matter what condition a vehicle or the remnants of a vehicle are in, generally we can still get the data from that.
Do you have any specific knowledge about Toyota data?
I do.
Describe that for us.
Beyond Toyota being a common vehicle in general, so we run into that data quite frequently. Just this year, we published a paper specifically studying some of the behaviors of the additional data recorder that's in Toyota vehicles.
Does Toyota make another sub-brand, for lack of a better phrase?
Lexus, I believe you're. Mm-hmm.
So Lexus is a Toyota brand. Broadly.
Correct.
Okay. What is infotainment? It's kind of a combination of a couple of words, information and entertainment. What is infotainment data as it relates to vehicles, modern vehicles?
So it's a generic term, which more or less means the thing that's in the middle of the dashboard with the screen on it. A lot of manufacturers implement that a little bit differently, so they all look different, but it's a general term we use in the industry to describe that system.
And what about, I'm going to change gears a little bit. What about your experience with regard to GPS as it relates to vehicles on the road, on the common roadways of the country?
GPS is a pretty fundamental part of vehicle data as a whole at this point, and we run into it in a lot of different places. We see GPS data from infotainment systems, so we're analyzing that data. Most of that's GPS based. I do a lot of heavy truck work, and almost every heavy truck has some kind of GPS system in it for the fleets to track them. So we're analyzing that as part of data. And then the last area would be when we conduct testing, any kind of research, we're generally going to put our own GPS systems on vehicles so we can study that data. So analyzing GPS is a regular part of my job.
GPS, global, I'm going by memory, global positioning satellites?
Global positioning system.
System, got it. GPS is a mechanism to figure out where on Earth a certain item might be, whether it's this pin or an 18-wheel tractor trailer, correct?
That's correct.
Is there any difference inherently in the GPS mechanism that's installed in an infotainment center in a Toyota Lexus versus a heavy truck or a heavy vehicle that's on the road?
The core technology behind how it works is fundamentally the same.
What is instrumented testing as it relates to Toyotas and VCH testing and things of that nature. Can you explain that for the jurors?
Sure. What instrumented testing means is, let's say we want to study, let's say, how accurate some data is that comes out of one of these vehicles. So we need an independent source of that information. So what we'll do is we'll equip a vehicle with one of these GPS data acquisition systems. Basically, we can drive the vehicle around and we know exactly where it is, how fast it's going, all these parameters. We can do some maneuvers with the vehicle. Then we can download the data that the vehicle stored, and now we can compare the two and say, okay, well, if we have really high confidence in our system, how accurate is the vehicle system? Because the reality is there's always some small errors in these vehicle systems. And in a lot of cases, what's important is quantifying that error.
So you're obviously familiar with GPS systems and many different platforms.
That's correct.
Okay. How many cases have you been a part of in terms of investigating and or analyzing infotainment center or infotainment system data?
Infotainment specifically, probably around 30.
And are you also familiar with engaging in some sort of analysis that's referred to as clock alignment?
Yes.
What is clock alignment?
Clock alignment would mean that anytime we have a timestamp in any set of data, a singular clock value, there's a good likelihood that that's not 100% accurate. So clock alignment would mean finding an independent source of time to compare that to, preferably one that's more reliable, and then making the necessary adjustments so that time can be considered real time.
How many cases have you been involved in that deal with clock alignment specifically?
Thousands, over 1,000. That's a regular part of data analysis. Any data set that has a timestamp, it's normal. It's part of the analysis. It's really the first step is let's get that clock aligned. So it's something I'm doing regularly.
And how long have you worked for Delta V?
It'll be my 13-year anniversary next month, actually.
Okay. These things that you've just described that we've talked about for the last few minutes, these are all duties that you perform within the rubric of your employment as the director of engineering at Delta V, correct?
Correct.
Now let's shift gears real quick and talk about your education, training, and background that qualifies you to perform these duties that you just talked about. Go ahead. The road is open and it's yours.
Certainly. So I began my academic career. I got an undergraduate degree in mechanical engineering from the University of North Carolina at Charlotte. I then went on and got a master's degree also in mechanical engineering from the same school. And then when I came out of school, I immediately started working for Delta V Forensic Engineering. In order to get a professional engineer license, I then needed to acquire 4 additional years of work directly under the supervision of another licensed engineer. So then I completed that phase of work. And then in order to maintain my license, I have to complete continuing education every year in the field that I practice.
So you got both a Bachelor of Science, correct?
Correct, Bachelor of Science.
Did you mention the year that you got your Bachelor of Science?
2011.
And you have a Master's?
Correct.
In engineering?
That is correct.
And when did you secure that degree?
2013.
You just mentioned engaging in continuing education. What is continuing education in terms of the engineering field or the reconstruction field in your world?
So in the state that I'm licensed, in North Carolina, they define that really as any activity you're participating in that's keeping you abreast with the field, keeping you up to date with what's going on. So taking formal classes counts for continuing education, but also some of the other work that I do, like publishing research in peer-reviewed journals, also counts as continuing education.
Do you regularly attend symposiums or symposia, I guess is the right
Yes.
word? Have you attended symposia related to EDR research and training?
Yes.
How about advanced applications of heavy vehicle EDR data?
Correct. Yeah, I attend. There's a couple of regular conferences in our industry specifically tailored to EDRs as a whole for passenger vehicles and heavy trucks. I'm a regular attendee of those. I'm also a regular speaker at most of those. And I'm usually presenting some of the new research that we have for that year.
So not only do you attend, you actually teach.
Correct.
Have you attended data, I'm sorry, have you attended data? Have you attended events that deal with data, event data recording systems, and event data recording system extraction?
Yes.
What about vehicle crash reconstruction?
Yes.
What about electronic control module imaging?
Yes.
What about electronic control model analysis?
Yes.
Applying automotive EDR data to traffic reconstruction?
Yes.
These are samples of the type of continuing education that you routinely engage in, correct?
All that's accurate.
You talked about additional licenses and professional registrations. You're a licensed professional engineer, correct?
That's correct.
In North Carolina?
Correct.
You're also a certified IPC specialist?
Yes.
What is an IPC specialist?
IPC is an organization that offers certifications in basically soldering. I could say it in more technical ways, but it boils down to soldering. So as it relates to what I do, when we are recovering data from damaged EDRs at the chip level, that involves some really precise soldering work. And so IPC offers courses in how to do that at basically the highest level. And then they offer certifications for that.
Are you a member of the Society of Automotive Engineers?
I am active member.
When you say an active member, is that a nationally recognized society for academic engineers?
Yes.
The teaching roles that you've held within organizations, have you been an instructor concerning accessing and interpreting heavy vehicle data event recorders?
I am. I'm currently an instructor of that course, which is offered through the Society of Automotive Engineers.
As a matter of fact, next week, are you going someplace to teach?
I am. I will be in Wisconsin next week teaching that very course.
Are you a member of any subcommittees within that organization, within the organization of the Society for Automotive Engineers?
I am. I am a voting member in the J2728 subcommittee, which is a subcommittee for event data recorders on trucks and buses.
Are you also a member of the National Association of Professional Reconstruction Specialists?
I am.
Does that require a certain level of education?
It does. And it requires, as far as I know, when I joined, sort of proof that you are active within the field of accident reconstruction.
That was my next question. It requires you to stay current on accident reconstruction issues, correct?
Correct.
Have you also authored peer-reviewed articles on within your field and
Yes.
subfield? Is it fair to say that you've authored or co-authored a number of peer-reviewed papers in the field of accident reconstruction specifically, as well as EDR data retrieval?
That's correct.
Have any of your peer-reviewed articles that you've either authored or co-authored specifically focused on Toyota vehicles?
Yes.
Can you name one, please?
Specifically, this year, published a paper where we studied the effects of collision-induced power loss on the way data is recorded in Toyota systems. And that would include Lexus systems. Fundamentally, they're the same components, it's just a different brand on top.
In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recording Testing?
Mr. Jackson, you're going to have to repeat that.
Of course. Sorry. In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recorder Testing?
Yes, I was the lead author on that paper.
When you're dealing with retrieving data from a vehicle, an EDR, an event data recorder, Toyota paper, whatever it might be, and that's a term of art, Toyota paper, correct?
Sure.
Does it matter if the vehicle is a heavy vehicle, a small vehicle, a passenger vehicle, a moped, or a skateboard if they happen to have an infotainment center on it?
There are differences, of course, between the data that comes out of passenger vehicles and the data that comes out of heavy trucks, but there are also a lot of fundamental similarities to those. Like, for example, they all record vehicle speed. They all have accelerator pedals. They all have brake pedals. So a lot of the core data we're analyzing is very similar.
In January 2020, did you co-author a publication entitled Chip and Board Level Digital Forensics of Cummins Heavy Vehicle Data Event Recorders?
Yes, I did.
Okay. And what was the fundamental, without getting into the granular details, the fundamental aspect of that paper?
So, in that research, we introduced a new technique for getting data out of damaged modules. So they're either burned, they've been submerged in the water, they're crushed physically from impact. We demonstrated a new method to be able to get data less invasively, but still at the chip level. And we also demonstrated that we could translate that data from the chips outside of the software that was provided. So you could use the software and get the data that way. We demonstrated we could basically do it ourselves if we wanted to.
Mr. Disogra, have you been qualified in other courts to testify as an expert in the area of accident reconstruction, EDR data retrieval? And recovery?
Yes.
How many times?
Once.
When was that?
In New York.
You were deemed qualified as an expert in that court in this field that you're talking about today.
Specifically with as it relates to data, yes.
I want to talk a little bit about what you were asked to do in this case. We asked to undertake a review of certain work performed by a person by the name of Shannon Burgess with Aperture LLC.
Yes.
Are you familiar with Aperture?
Yes.
Before you were asked to undertake that review, were you familiar with Aperture?
Yes.
Were you familiar specifically with Shannon Burgess?
Yes.
Were you asked to engage in any original analysis in this case?
All of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So more or less the answer to your question is no.
So you were asked specifically to give the court and the jurors clarity on data that Shannon Burgess had analyzed and provided a report about, correct?
Correct.
And that dealt with data obtained from Miss Reed's SUV, Karen Reed's SUV, correct?
Correct.
Did you in fact review Shannon Burgess's report summarizing his findings and conclusions regarding clock drift? That report was dated in January of 2025.
Yes.
And what did you do in that regard?
I analyzed the methods that Mr. Burgess proposed for aligning the clocks in that report.
Were you also asked at some point to review Judson Welcher's report and PowerPoint presentation regarding the timing of the text stream event known as 1162-2, 1162-2?
Yes.
Did you determine whether Dr. Welcher had based his report on Shannon Burgess's analysis?
Yes.
Before we get into that, I want to ask you a couple of questions about text stream events. So we're all talking sort of with the same vocabulary if we could. When I say text stream event, have you ever heard that called a trigger event?
Yes.
Are those sort of synonymous?
The event, in order to be generated, has to be triggered by something. So, yes.
You became aware in your analysis, I'm assuming, that Dr. Welcher reported a trigger event at a particular time or span of time, correct?
Correct.
What span of time was that? I should say, what time was that?
For which event?
For the 1162-2 event, sorry.
Do you mind if I reference the slide? Because I don't have the number committed.
With the court's
to
permission.
Go ahead.
Do you have a copy of it in front of you?
I do, Your Honor. So the original analysis places event 1162-2 ending at 12:31:43 a.m.
Now, Dr. Welcher, this is what I want to talk about for just a quick second. Dr. Welcher indicated that the trigger event began at 12:31:38, correct?
I believe so.
That would suggest that a trigger event lasts 5 seconds, 12:31:38 to 12:31:43, correct?
Objection.
Sustained is to form.
Let me ask you this. Does a trigger event or does a text stream event last 5 seconds or 10 seconds?
The trigger is a singular point in time.
That's my question. All right, so if we're thinking about a trigger event, it's like that clap, snap, right? It's a point in time, not a series of, not a time span, correct?
It's a singular point, correct?
Okay. Does a trigger event or a text stream event cause a recording to bookend the trigger event itself?
Yes.
Explain that for the jurors so that we're very clear about that.
Sure. So when an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording. And as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary. It can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
Right. So if Dr. Welcher indicated that the text stream event, the trigger, was at 12:31:38, would it be accurate if he said that trigger ended at 12:31:43?
Sustained is to form.
Is there any, if a trigger event is one point in time, one snap in time, would it be accurate to say that the trigger event itself lasted 5 seconds and ended 5 seconds later?
It wouldn't be accurate to say the trigger lasted that long.
That's my question.
The event lasts that long, but the trigger is only one point within the event.
The recording lasts that long,
Right.
correct?
Correct.
So in other words, it captures, or does it, let me ask you this, does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle.
That's correct.
Okay. If we were to calculate the window between the trigger event or the text stream event and a lock event on John O'Keefe's phone, you analyzed both, correct? Or you reviewed both, correct?
Correct.
Would you calculate from the point of the trigger, would you calculate from 12:31:38, that point in time, and I'm using the tip of my pen to represent the point, at 12:31:38, or would you calculate it from 12:31:43?
Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the aperture reports was referenced off of the end of the event. So
Of the recording event.
Of the recording event.
Not
So,
the trigger.
Correct. And I didn't correct that. I just went with that convention for all of the analysis I did.
But you noted it, correct?
Correct.
And you noted that that would be 5 seconds inaccurate. I'll withdraw it. I'll ask it a different way. What would be the effect of timing if you were to start at the trigger event, 12:31:38, versus timing the event if you were to start at 12:31:43?
There'd be approximately 5-second difference in every subsequent calculation.
And if, in fact, there was a lock event, which you reviewed, at 12:32:09, how long would the actual window be from the trigger event to 12:32:09?
It would be larger by 5 seconds, approximately.
So it would actually be 31 seconds, correct? Did I do my math right?
You did.
Let's get back, if we can, to the offsets that you identified in Shannon Burgess's, the time offsets that you identified in Shannon Burgess's report. When you applied the potential offsets identified by Mr. Burgess to the text stream event at 1162-2, what opinions or conclusions did you come to with regard to that analysis or that question?
Sustained, ask it differently.
Did you apply the potential offsets identified by Mr. Burgess in his January 2025 report to the tech stream event 1162-2?
Yes.
Did you also apply Dr. Welcher's analysis based on that same Shannon Burgess analysis to reach an opinion or a conclusion?
Yes.
And what was your opinion or conclusion with regard to that event and the timing following that event?
Based on all of the data in those two original reports, regardless of what adjustment is made or which 2 points are used to try to correct the clock, the phone lock event always occurs after the end of the event, using their convention of referencing off the end of the event, not the trigger, but it always occurs after.
And that was based on Shannon Burgess's January 2025 report, correct?
Correct.
Sustained.
What was that based on? Which report? We're dealing with two different reports, May and January. I want to make sure we differentiate. Which report are you just now talking about?
I'm talking about the January report.
Now, did Mr. Burgess, were you supplied with a supplemental report by Mr. Burgess?
Yes, I was.
When was that?
Slightly after he issued it, but I don't know the exact date.
Say that again?
It was issued on, his report was dated May 8th, and I think I was provided it a couple days after that. I don't
Okay.
remember the exact date.
So after, well, do you know when this trial started?
No, I don't know the exact date.
I know you're not watching the trial, but it was in the middle of this trial, correct?
Sustained.
I'll ask a different question. With regard to the original report, the January 2025 report, was there any circumstance in which Mr. Burgess and Mr. Welcher could conclude that the lock event on John O'Keefe's phone, that lock event, occurred before the trigger event?
Objection.
Sustained. Ask it differently, Mr. Jackson.
What is your opinion about whether or not there was any analysis done by Mr. Burgess or Mr. Welcher that put the lock event occurring before the trigger?
Objection.
Sustained.
May we approach, Your Honor?
Yes.
I'm not going to get the witness to say what I want to say if you keep sustaining the Commonwealth's objections, Mom. It's not a good look to keep having your sustained objections, and there were a lot of them. This is an important witness for them. They're going to go against the timing. As they should. I mean, they've got to pick apart the experts. I will admit I don't know that much about it, but with the way that Mr. Jackson is doing spaghetti questions, and with that's like my phrase, and I think Rocket Couch uses it also, for when they just throw anything against the wall to see what will stick, or the tangled web, the big bunch of looped noodles. I'm not sure. Like, I don't think we went to, did we go, is it number 3? Can anybody else help us and weigh in? I think.
May I, Your Honor?
Yes.
Thank you. Back to my question. Was there any circumstance based on your review that if the tech stream event occurred at 12/31/38, that there was any circumstance that the lock event occurred before that trigger event?
There was not.
Well, why would it occur before it? Doesn't that help the Commonwealth? Am I
Did you
wrong?
create a PowerPoint for clarity's sake in March of 2025?
Yes,
Did you provide that to us?
I did.
What was the purpose of creating the PowerPoint?
The purpose of the PowerPoint was really to take a bunch of different data elements that were kind of placed throughout Mr. Burgess's report and Dr. Welcher's report in PowerPoint and compile them into a single source, a single table, essentially, to show as clearly as possible what the conclusions would be if we look at the data as a whole.
When you created that PowerPoint presentation, did you create it with the intention of providing it to the defense, which would then be provided to the Commonwealth?
Yes.
Are you aware of whether or not that was disclosed to the Commonwealth as part of the normal discovery process?
No.
So the answer is no, the answer is.
Following your presentation of the PowerPoint to us, at some point, did you receive from Mr. Burgess an amended report, an amended PowerPoint?
I received an amended PowerPoint by Mr. Burgess, not from him, though, from you.
Fair enough. Fair enough. Did that report or did that PowerPoint, however you want to put it, markedly, was it any different than his January 2025 report?
Yes.
Did you note any conclusions? Did you note the conclusions that he came to in January 2025? Going back to the original report?
Yes.
Did you note conclusions and opinions that he came to in May of 2025?
Yes.
Were those two things different?
Sustained.
Were the conclusions, not his opinions, were his conclusions different?
Sustained.
Was there any difference in the two reports?
There was.
Tell me the differences.
In the first report, Mr. Burgess did some of the calculations that are necessary to correct or adjust the times based on certain approaches, but never went through the final step of applying those calculations to the times and coming up with a final time. In the supplemental report, he then essentially took that analysis to the end. He approached it in a new way, a different way than he had previously laid out in the first report, but then he also took it all the way to the end by applying those calculations to the times.
What were the main differences? Explain for the court and for the jurors, what were the main differences that he changed in the May 2025 report?
Contrasting it with the original
Correct.
report. In the original report, he laid out some methodologies for correcting the clock using phone calls that were shared between the vehicle and Mr. O'Keefe's phone. And in the supplemental report, he moved away from the phone call analysis and moved to attempting to align the clocks using a shared maneuver between the vehicle and the phone.
What was the shared maneuver?
It was a 3-point turn.
Was that the same analysis that he had in January 2025?
He did not have that analysis in the January 2025 report.
Thank you. Based on the new information in the May 2025 report, what was the effect, as you see it, regarding the possible scenarios?
So I did the exact same process I did using the supplemental report as I did on the first report. And when I ran all those numbers and those calculations, it turned out there are now some scenarios in which the phone lock occurs after the end of the event. There's some scenarios where the phone lock occurs simultaneously, like literally at the same second. And there are some scenarios where it occurs before. So now there's a range.
So Mr. Burgess's report, his new report, his amended report, widened that gap to allow him to opine that there were scenarios that occurred after the phone lock event, correct?
Objection.
The objection sustained.
Did you prepare a PowerPoint presentation in furtherance of clarifying Mr. Burgess's analysis?
Objection.
Sustained.
Did you seek to clarify Mr. Burgess's analysis?
Objection.
Sustained.
Your Honor, may we approach?
Yes.
Apparently, they were at another sidebar. The Commonwealth must have won an argument in regards to certain testimony that the man cannot testify to. But the Commonwealth, as usual, is objecting, of course, because Alan Jackson, like he don't care. Like if they tell him he can't, he's gonna keep trying. It's not a good look in front of the jury. I mean, I want the information to come out, but it has to come out succinctly so the jury understands it. At this point, I'm pretty confused. I mean, they can attack the methodology, and they will. And it sounds like he is. He's saying that, depending on how you do the application of the time difference and what you apply it to, you can come up with different results. I'm thinking this is number 3. I'm not sure if I missed one. Coach and I still can't tell if the last one was 2 or 3. I said it was 2 because I only remember typing it. And I don't remember I remember the fan coming up while we waited for jury, but that's it. Unless I nodded out. Did I space out? I don't know. I haven't finished my second cup of coffee yet, so could be. Could be. Well, so far this is pretty sedate. Alan Jackson is not yelling yet. Oh. I do like Jackson's tie, though, this morning.
May I?
Yes.
Did you prepare a PowerPoint presentation in furtherance of your analysis?
Yes.
What was the reason, and what was the purpose for your PowerPoint presentation?
I needed to include in my analysis the approach and the conclusions from the supplemental report by Mr. Burgess.
May I have a moment, Your Honor?
Yes.
May I approach?
Yes.
Okay, he said.
If you don't mind taking a look at that document, it's a multi-page document I just handed you, and just flip through it and let me know once you've familiarized yourself with it. What is that document?
This is a printout of the PowerPoint presentation that I prepared.
Is it true and accurate?
Yes,
And it's complete?
it appears to be.
Your Honor, I would move for its admission, please.
I have no objection.
May I have that back from you for just a quick second?
208.
Thank you.
Your Honor, permission to display the PowerPoint presentation?
Okay.
Mr. Disogra, can you still see with the lights off sufficient to see what's on the screen and what's in front of you?
Yes.
Okay. Do you recognize what's on the screen?
Yes.
What is that?
That is the title page of the PowerPoint that I prepared.
And what is how would you describe the PowerPoint?
So this PowerPoint is largely identical to the first PowerPoint I prepared in that it seeks to take all of the different approaches between the initial Burgess report, the supplemental Burgess report, and Dr. Welcher's report, lay out all of those approaches in one kind of coherent fashion so we can look at what conclusions we can draw from all of that data.
With court's permission, can we go to slide 2?
Yes. Mr. Jackson, you can just use this PowerPoint. It's in evidence. You don't have to ask slide to slide.
Thank you, Your Honor. Taking a look at this next slide, what is this? What are we looking at?
This is a slide from Dr. Welcher's presentation that I was provided. Specifically, this is his slide number 33.
And what does it show?
This is where he introduces the first, I guess, acknowledgement that there's a difference between the time that Aperture calculated for the end of event 1162-2 and the lock event on Mr. O'Keefe's cell phone.
Is there anything in this slide that you disagree with in Mr. Welcher's presentation that you disagree with? It's up on the...
I added the 2 green boxes and the text, the word after. That's not Dr. Welcher's. And I added that because it's stated here that the event occurred within 26 seconds. But if we do the math, and he actually does the math, he really means after. It means the phone lock event occurred 26 seconds after the end of the vehicle event as calculated.
No, I'm going to allow it.
The phone interaction happens how many seconds after the text stream event?
Based on this slide, 26 seconds.
Thank you. And the text stream event that we're talking about is what number?
1162-2.
And this slide, other than the green, is this slide or the portion of the slide that we're looking at, other than what you've described, is this directly from Mr. Welcher's own analysis or his PowerPoint?
Right. I added the green box around within, the dashed green box around the whole paragraph, the line, and the words after. Those are my additions.
Let's go to the next slide. Can you tell us what this is?
This is more or less a repeat of what's on the first slide, but just shown with a little more focus. The first slide is a little busy. So
did you, I'm sorry, Mr. Disogra, did you create this or is this from Dr. Welcher's report?
I created everything on this slide apart from in the top right. That came from Dr. Welcher's slide 33.
Although you created the slide, where's the data coming from for this slide?
All of the data on this slide and all of my subsequent slides comes from the Aperture reports collectively, either Dr. Welcher's report or slides or Mr. Burgess's first and second reports.
What did their analysis reveal in terms of the time, the exact time of the lock event for Mr. O'Keefe's phone?
So in their analysis, in Aperture's analysis, they report the Lexus event 1162-2 ends at 12:31:43. And they also report there's a phone lock at 12:32:09. So if we just simply take the difference in those two times, we get 26 seconds.
If you were to add the 5 seconds back to 12:31:38, which is the actual trigger event, what would you come up with?
31 seconds.
Which of the two, in your expert opinion, which of those two numbers is more accurate as it relates to the trigger event?
If we wanted to conduct the analysis relative to the trigger, it would be better to use the actual trigger time. However, as long as we're consistent through the analysis, it's not entirely wrong to use the end. It would be wrong if I suddenly switched up and started talking about this relative to the trigger event, but they present it as the end of the event. So I conduct the rest of my analysis using that convention.
Is another word for the end of the event the end of the recording?
End of the recording, yeah. When I say event, what I mean by that is the data event, the data recording event.
But the trigger event itself, 12:31:38.
Correct.
Okay. Did you put a name on this gap, if you will, this time frame?
Yes, I did. For the sake of the rest of the analysis that I'm going to do, I thought it would be helpful to just refer to this difference in time as John's interaction window.
And that refers directly to the interaction with the phone, the human interaction of locking the phone.
The 12:32:09 lock.
Okay, let's go to the next slide, please. What does this slide show us?
So this here, what I'm doing is I'm kind of laying out the bounds of what I mean in John's interaction window which should make, you have a lot of numbers to go through here. And so this should give us a very easy metric for kind of determining whether we have an event before or after. So what I mean by that is when we calculate John's interaction window, if that number comes out and is positive, that means the phone interaction occurs after the end of the vehicle event. And if we calculate John's interaction window and that number becomes a negative value, then that means the phone interaction occurs before. So now we have just a convention we can use really quickly to say, is it positive or is it negative? And we can maybe spare ourselves some of the math with 1,000 numbers.
So positive means what? One more time.
Positive, John's interaction window positive means the phone lock occurs after the end of vehicle event 1162-2.
Got it. Let's go to the next slide, please. What does this slide show us?
So what I'm saying here, I'm kind of laying the foundation for why we're going to even do this. Why do we need to start doing math on these clocks? So fundamentally, the phone, Mr. O'Keefe's phone, and the vehicle, Ms. Reed's vehicle, they're separate clocks. And it's very unlikely that they're going to be aligned perfectly in time. Right? If I compared my watch to your watch, it would probably be off. And that's the same case for any two independent clock sources. So Aperture, in their collective reports, propose a number of different ways in which that can be corrected. So I'm going to go through all of those ways that Aperture has proposed and show if we align the clocks based on how they laid out, does John's interaction window stay positive or does it ever become negative? Where does it end up when we run all those analyses? Or another way to put it is, does the phone interaction always occur after the end of the vehicle event?
And what did you determine?
Based on the initial reports,
Yes.
the phone interaction always occurs after the end of the vehicle event.
Did all of the information that's on this slide come from the same source or multiple sources, meaning Mr. Burgess and Dr. Welcher?
In the PowerPoint as a whole, all the information comes from the Aperture reports collectively.
Okay.
From Dr. Welcher and Mr. Burgess.
Did Mr. Burgess make any adjustments from his original report to his subsequent report in May of 2025?
Yes.
Let's go to slide 6, please. Tell me about this slide.
Yeah, so this is the first adjustment we're going to talk about and this one comes from Mr. Burgess's original report. And to summarize this adjustment, this is a key on timing adjustment. And we're going to show that the key on, the actual turning of the vehicle on, occurs about 3 seconds before that time gets registered in the infotainment. So the time we see is basically stale by 3 seconds.
We're all familiar with how computers turn on. When you say key on, do you mean a physical key or could it be the push button to turn the car on?
In this case, it's a button. I refer to key on because generally that event is considered the key on in vehicle parlance, regardless of whether there's a physical key or it's a push button.
So those 3 seconds mean what? What's the difference between pushing that button and the 3 seconds later that you just described?
It means that when we're trying to use the timestamps that were recovered from the infotainment system that show when the vehicle was keyed on or turned on, that the vehicle was actually or likely turned on 3 seconds before that.
Do you know where the 3 second conclusion came from in Mr. Burgess's report?
That came from the testing that Aperture conducted with the exemplar Lexus that they purchased.
Was there anything in the report that indicated testing, this type of exact testing on Miss Reed's actual Lexus?
No.
Do you have an opinion as to whether or not all Lexuses, at least of this make and model and year, would have the exact same 3 second delay? Or could that be different?
It could be different in their testing. In their testing, they only tested one exemplar vehicle. So I think there was a solid foundation that the exemplar that was used exhibited this 3-second delay. It was a very close match in terms of part numbers and software versions to Ms. Reed's Lexus, but without any kind of testing of, let's say, a second vehicle, a second exemplar, we wouldn't know, we wouldn't have any basis to say it must be 3. We could test a second vehicle and it could be 5. So we say, well, there's a delay, but it varies vehicle to vehicle. They could have tested a second vehicle and found it's also 3. And then you start to build some confidence that maybe it is 3 across every vehicle. But with only testing 1 and not testing the subject vehicle, it is difficult to say with absolute certainty it would be 3 seconds.
What is your opinion about best practices with regard to trying to create this gap for purposes of coming to an opinion or an analysis?
So because we don't know whether or not this specifically would apply to Ms. Reed's vehicle, the best way to conduct that analysis would be to do the entire thing with the key switch adjustment at 3 seconds. Because if we're going to use a value, 3 is the most reasonable one because that's the one shown in testing. But we should also do the entire analysis without it in case we feel that that's the most appropriate. So in fact, that's what I do and will show is I ran the analysis both ways, with and without, to be as conservative as possible.
Did your review of Mr. Burgess's report indicate that he ran the analysis both ways?
He did not.
Let's go to slide 7. What are we looking at here?
This is an excerpt from Mr. Burgess's original report. His page 28 and his page, there's a screenshot also from his page 30 at the bottom. And this is where he states in that report that when they were doing the testing with the exemplar, they observed across 4 different key-on cycles this 3-second difference. So what I mean by that is they had a video camera in the car that had a timer on it. And so in the video, you can see the button pressed. So in their testing, for example, they pressed the button at 21:48:05, and that's sort of nailed down. When they went back and downloaded the data from the infotainment, the key-on was logged in the infotainment as 21:48:08. So there's the 3 seconds. That's where they're getting that from. And that's what he states highlighted in red there. It's a little hard to read, but it basically says the average across 4 runs was 3 seconds.
The 3-second delay, was that actually in his report?
This is the only point in the report it's mentioned.
I guess what I'm asking, it was an inartful question. The portion to the left, is that his report or your report?
That is his report. Everything on the left-hand side of this slide comes from Mr. Burgess's report.
So the 3-second delay was noted in his report?
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
Did he indicate in his report why he ignored that 3-second delay?
He did not.
Sustained as to that question.
I'll rephrase it.
Strike the answer.
Did he indicate in his report the reason that he did not apply the 3-second correction?
He did not.
When you do apply the 3-second correction, what do you come up with as it relates to the 26 seconds from the end of the recording?
So the positive 26-second window, if we only apply the 3-second key on, grows to positive 29 seconds.
If you applied the same 3 seconds to the trigger event time, now what does the gap?
That gap would grow to a positive 34 seconds.
Between the trigger event and what?
The phone lock.
In your opinion, was it best practice to not account for that 3-second delay between the on switch and the data coming on?
Sustained, ask it differently.
what in your opinion would be the best practice in terms of this 3 seconds that was noted in the exemplar vehicle?
The best practice would be to run the analysis with that adjustment included and without that adjustment included. Because like I stated, without testing of an additional vehicle, we really don't know if the 3 seconds is just a specific behavior of that exemplar or if it's representative of all Lexuses of this type.
Let's go to slide 8, please. Tell us what we're looking at in this slide.
So now we're going to get into the next adjustments. That first adjustment we just talked about was really a vehicle-to-vehicle adjustment. We haven't talked about the phone yet. We're going to get into the phone now and talk about aligning that. But we had to get through the internal adjustment that has to get done first. Now we're going to look on the subsequent slides here at all of the different ways the aperture reports compared the vehicle to Mr. O'Keefe's phone.
Is there any additional adjustment that you believe should be made?
The aperture reports lay out 2 methodologies for adjusting. There is a methodology based on phone calls, and there's a methodology based on the 3-point term.
And where did you get that information from?
From the aperture reports.
In Mr. Burgess's original report on differentiating, the January report, which did he use to determine his determination of the clock skew?
In his initial January report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2, but he does do the math, which I'll show, for the differences on these phone calls.
In terms of Dr. Welcher's report, did he identify a GPS point of 154 at all?
Yes.
How did he describe that GPS data point?
He describes in his initial PowerPoint slides as point 154 aligning with the end of vehicle event 1162-1, talking about a different event now. This is the 3-point turn event. So he uses that as an anchor point.
And that anchor point you said was the end of the text stream event, or the end of the recording of that text stream event.
Correct. The aperture reports consistently reference everything from the end of the events.
Let's go to slide 9, please. What are we looking at here?
On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist both in the infotainment from Ms. Reed's Lexus and in Mr. O'Keefe's phone. He puts them in a table form. Then he actually goes on and calculates the difference between those 2 times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times. So that's where I step in and say, if I take that 3rd column that he lays out, those are in seconds. If I apply those seconds, that adjustment to 12:31:43, where do we end up with John's interaction window in those times?
What did you conclude in terms of finishing the work?
Sure, I did all of them. And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them.
Did you ultimately apply all of the offsets?
Yes, I did.
And what did you determine?
Regardless of which offset you apply, John's interaction window remains positive. the number changes, but it remains positive.
Let's take a look at those one at a time if we can. Let's have the next slide.
So on this slide, I just took the other end of the spectrum. There's a large range in values in this table. He doesn't actually, Mr. Burgess doesn't show the sign conventions on here, but actually
sign conventions.
Sign conventions, he doesn't show when he calculates the difference, whether it's positive or negative. All the numbers in the table don't have a sign, don't have a plus or minus in front of them, but there's an implication. Some of them are plus, some of them are minus. So the first one that we just looked at showed we had 2 seconds slow. There's another value in here that's on the other end of that. It shows that Mr. O'Keefe's phone is 21 seconds fast now relative to the infotainment. So that's the largest value in the table we could take that would bring John's interaction window down now. And so if we apply just that adjustment, John's interaction window becomes a positive 5.
Take a look at slide 11, if we could, please. What are we looking at here?
So I've shifted now from the phone calls, and now we're going to talk about the 3-point turn alignment. In the 3-point turn alignment is first presented in Dr. Welcher's slide from his presentation here. And in this, he doesn't say it explicitly, but he provides some math on the screen, which is a little hard to read. But he puts some math on the screen that shows he's aligning this 0.154 from Mr. O'Keefe's phone to the end of event 1162-1. This is the prior event. This is a 3-point turn. And so he aligns, he says this is basically how you align it, and he doesn't do the math. Again, he lays out that he says a 19.2 second difference. I actually just adjusted that to 20, which is the most conservative way to interpret that. I don't think we have the accuracy here to talk about tenths of a second. Nevertheless, I just rounded that up to 20. And when we apply that 20 seconds to our event 1162-2, then John's interaction window becomes positive 6. That's just applying this. We're not combining anything. We're just applying the difference shown in this slide.
And that positive interaction window, is that calculated based on information directly from Dr. Welcher's report?
Yes.
Let's go to slide 12. What are we looking at here? What is this table?
This is a table I made. We've talked about a lot of different approaches to how these clocks can be aligned and a lot of different variables. So I tried to summarize them in one table, put them all together, because some of them we can combine. We can combine the key on with either a phone call or a 3-point turn, but we can't combine, for example, a 3-point turn and a phone call. That's not valid. So I put all the possible combinations, all of them, with, without key switch, phone calls, and 0.154 on one table, and I calculated John's interaction window for all valid combinations from the aperture reports. And when we do that, the result is that regardless of what adjustment we make, all of the numbers are positive, meaning regardless of what adjustment we make, the phone lock event always occurs after the end of event 1162-2.
Did Mr. Burgess, in your review of his report in January of 2025, did he ever undertake all possible offset calculations?
No.
In his May 2025 report, did he undertake all possible offset calculations?
No.
What is your opinion in terms of best practices regarding calculations of this sort?
I think if there's sufficient data, if there's testing or research or literature that in a specific case supports there is a best path or a best method, then we should use that. In this case, I don't think there is a best practice. There isn't any literature I'm aware of that would specify exactly the best path to align all of these. So in the absence of any external data to support one path, the most valid approach is look at all of them as a whole and then draw the conclusion from the totality of that data, rather than cherry picking a single point.
Can you testify to a reasonable degree of scientific certainty whether all potential offsets that were described in Aperture's original report, January of 2025, result in a positive interaction window?
Yes.
And what is that opinion?
Regardless of what adjustment or combination of adjustments we make from the original reports, John's interaction window remains positive.
Does the positive interaction window mean the lock event occurred after or before the text stream event?
It means the lock event occurs after the end of the text stream event, 1162-2.
You've already indicated that you received a second report, May of 2025, correct?
That's correct.
In that report, is there the same clock skew alignment or a different clock skew alignment that Mr. Burgess now undertakes?
Mr. Burgess undertakes a different alignment in that report.
Let's go to slide 13. Describe what we're looking at in this slide.
So what I have here on the left is a screenshot of page 42 from Mr. Burgess's supplemental report. And so now he's done two things new here. He's identified a new method for aligning the data based on the 3-point turn. So now he's kind of following where Dr. Welcher started, but he's approaching it a little differently. And secondly, he is now calculating the actual time. He's doing the difference calculation and he's applying that to the time. So now he's taking the calculation all the way through, which is a little different from the prior reports. And so when he does that, he makes my job really easy because I didn't have to do really any math now. He comes up that there is a range now. So prior to this point, the original report by Mr. Burgess and Dr. Welcher reports all used discrete points in time, right? They sought to find an event that occurs at a singular second and another event at a singular second and align based on that. This is a little bit of a departure from that approach. Mr. Burgess is now using a range of times, a range of uncertainty. He basically assesses that the 3-point turn data from the phone and the 3-point turn data in 1162-1 cannot be precisely aligned down to a single point. Rather, they overlap in this range of seconds. And so he then says that that range must be applied. So now we have to apply a range. And what we end up with is 9 possible values. So it kind of looks like one conclusion, but really there's 9 conclusions on this slide. And so if we just applying the math he has in the supplemental report, John's interaction window now has a range of 9 possible values. And that range spans from +5 now to -3. So we have 5 positive values. We have 1 value that's 0, and the 0 would mean it's simultaneous. And then we have 3 negative values.
Does Mr. Burgess indicate in his report that any one of those values is more likely than any of the other values?
He does not provide any data or analysis to support one point being preferential over the other 8.
And are there more or fewer positive results in his analysis than negative?
There are more positive numbers in that range of 9 than there are negative numbers.
Does Mr. Burgess's new data indicate anything about Dr. Welcher's analysis about the GPS data point 154 being at the end of the 3-point turn?
He opines in that aligning the 3-point turn on a singular point is not, and I'm paraphrasing because I don't know the exact way he states it, but not the preferred method.
is Mr. Burgess's analysis consistent or inconsistent with Mr. Welcher's determination that GPS point 154 was at the end of the text stream event?
Objection.
Sustained.
Does Mr. Burgess in his report indicate whether he agrees or disagrees with Dr. Welcher's analysis?
I don't remember specifically.
In your opinion, I asked you about Mr. Burgess's report. Now I'm going to ask you about your opinion. In your opinion, is this new offset any more likely or reasonable than any other offsets previously proposed by Mr. Burgess?
I don't think it is more or less likely. I think it is a valid approach, certainly. And so I think the results from the additional analysis should be included with the analysis of all of the results so far.
And none of those results are more or less likely than any of the others, correct?
Sustained.
Are any of the results, in your opinion, to a reasonable degree of scientific certainty, are any of the results any more or less likely than any of the others?
It's my opinion they're all equally weighted.
Did Mr. Burgess account for the 3-second offset that we talked about earlier in his May 2025 report, his new report?
I did not see any mention of that in his supplemental report, and certainly it's the 3 seconds isn't present in his math. I don't see it there.
Let's go on to slide 14, please. Describe what we're looking at here in this table.
This is very similar to the table we looked at previously, where I look at all possible combinations. Now, however, I just have a lot more data points to show, so I've had to break the table into 2 tables. So we're going to look at this, and then we'll look at slide 15 next, which is the second table. I just couldn't cram 30 lines onto one slide.
Let's move to the next slide then. Is this a continuation of
the
the
second half? So think of these as a singular table. I just had to split them up. If we head back to slide 14, we'll start there. So this slide, I'm not accounting for the key on, and that's the main difference between my 2 tables. Table 1, I'm not accounting for the 3-second key on. In table 2, I am.
When you say key on, you're talking about that 3-second delay.
Correct.
Okay, go ahead.
But again, I want to make sure we're thinking about this as a singular table because that's where we'll draw our conclusions from. So the first lines of the table, we've already seen those. Those were in my original table. I haven't changed those. That's the same math that's been there. All I did was I added the 9 points now from Mr. Burgess's supplemental report using the range he shows. And so now we can see if we include that, now we get some positive numbers for John's interaction window. We get that 0. And again, the 0 would imply that the end of event 1162-2 is happening exactly at the same second as the phone lock. So it's kind of not on one side or the other. So I think it should be thought of as separate. And then we have 3 negative values, which would imply that phone lock occurs before the end of 1162-2.
And did you already mention the one that was simultaneous?
When John's interaction window is 0, correct?
0.
That would imply simultaneity.
All right, is this 14 or 15? This 14, let's move to 15. Now, this is a continuation of that. Mentally, we'll just continue that same table?
Correct.
Okay.
Just a continuation. Imagine in your mind is just rows 16 to 30.
Okay.
And it's the same thing, same format, except for now we're just adding in that key on adjustment because again, I think the analysis should be run with and without it. And so now when we run this with the key on adjustment, we get 14 of these 15 are John's interaction window is positive to various degrees. And one of them, it's 0, again, simultaneous. And there are no negative values with this adjustment.
Can we go to the next slide, 16, please? What are we looking at here?
This is the summary then of that table, kind of a verbal summary of the giant 30-line table now. And if we look at all of the possibilities from all of the aperture reports collectively, then we can draw some pretty straightforward conclusions. 25 of those 30 possibilities result in interaction with the O'Keefe phone after the end of event 1162-2. Looking at all the possibilities, 2 of the 30 result in interaction where it's simultaneous. That's the zeros, they're present in both tables. And then looking at all 30, 3 of the 30 result in interaction with the phone before the end of event 1162-2.
Do you have an opinion as to which of these particular offsets that you've described, these 30 possibilities, should be applied in this case?
No.
Why is that?
Each of the approaches have their own individual strengths, and each of them have their own individual weaknesses. And there is not really any published literature, any research, or any testing done that I'm aware of that would suggest one really stands head and shoulders above another one of the methods. So I think the most fair way to present it is to look at, again, if we combine everything together, then we can draw some conclusions like this in terms of how many of the total result in one outcome or another.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis, is there any ability to say to a reasonable degree of scientific certainty that the text stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Do you have an opinion to a reasonable degree of scientific certainty that it did happen after the text stream event?
Sustained.
Of the 30, what's the percentage of possible events that occurred, possible scenarios, I should say, wherein the text stream event occurred after the last interaction with John's phone? What's the percentage?
That's sustained.
You said it's 3 out of 30, correct?
Yes,
Is that 10%?
that is 10%.
Yeah, it's sustained and it's stricken.
What percentage is 3? Just do basic math for me. What is the percentage between 3 and 30?
Sustained.
If I told you hypothetically,
I'm going to see your sidebar for a second.
Gee, how did I know that was coming? You know, when he gets objected to and it gets sustained, and that sustained means stop it. Like, move on. You know, you can't go there. So what does he do? He goes there. And he goes there again. And he gets objected again. And then he gets objected again. Then there's a sidebar. I'm sensing a pattern this morning. Must be all the math talk. Oh, couch, we're on the same page. They're grasping at straws. They're hoping that their witness will shade the data enough to hear towards. Actually, he's not. He's just talking about the multiple possibilities. There's no gotcha in there. And, you know, I don't know. Maybe somebody could help me out here. I'm confused because even if the phone did stop after the trigger event, that makes sense to me. It takes a few moments of inactivity to lock a phone, doesn't it? And at the trigger event, if it was in his hand, wouldn't the phone be moving? So, like, What's the point? I honestly am thinking that this actually helps the Commonwealth in not the defense. But I'm confused. Like maybe I'm missing something. I was hoping somebody could help me out here. I'm looking on the socials. Like I'm gonna have to really scrub through the lawyers' stuff today, see if they've got an expert that knows anything. Because this is really soft sell to me. That's right. They have a reputation to maintain. You're right, Rodin. This man is not doubling down. They have paid him for his opinion, but his opinion is mediocre. He's saying there's not enough data. I think the only thing it does, I will give them this. What it does do is say that if Shannon Burgess or Justin Welcher actually came forward with a solid, this is how it is, which Dr. Welcher didn't. He said of all the possibilities, like this is that. It just narrows the window. The window is still very narrow. Still not enough time for all that stuff at the house, like they said.
Following your analysis of the totality of the possible scenarios, did you come to a conclusion that the vast majority, let me rephrase that, did you come to any conclusion about the numbers as they relate to the positive interactions versus the negative? And when I say positive versus negative, I'm talking about the phraseology that you used. John's phone interaction being in the positive side versus John's phone interaction being in the negative side.
Yes.
And what were those?
Of the 30 possibilities, 25 of them, it's a positive. John's interaction window is positive for 25 of them.
And only 3 were negative?
Correct. Only 3 were of the 30 were negative.
Okay, we can take that slide down. Is there a data recorder on the Toyota SUV that we've been talking about, that 2021 Toyota SUV 570, that's designed to record impact?
Yes.
What is that? What is that mechanism?
That would be the airbag control module,
The ACM?
ACM.
Did you look at that?
I was provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
Did the vehicle control history record whether there was any history of a collision on that car, ever?
No.
What does the vehicle control history record specifically?
It records a lot of operational parameters about the vehicle. What I mean by that is it records things like what the driver is doing, for example, steering wheel angle, accelerator pedal position, whether the brake is being pressed. It also records what the vehicle is doing, for example, speed or the engine RPM or the accelerations of it.
Does the TechStream data event indicate that there's a, and I'm talking about very specifically the TechStream data, does that indicate whether or not there's a collision in the car?
No.
Does the TechStream data event mean that if you find a TechStream data event or a trigger event, does that mean that the airbags are deployed?
No.
Does it mean that the vehicle impacted with something solid?
No.
Does it mean that the vehicle impacted with a pedestrian?
No.
You reviewed the raw TechStream data associated with the entirety of Ms. Reed's vehicle, did you not?
Yes.
How many TechStream events or triggers were found on Ms. Reed's vehicle during the course of the 8-month period prior to January 29th?
So can you narrow that, Mr. Jackson?
Sure.
I object to the whole line.
And I need to see what's up.
Number 5. We're cooking them. I think we're going to get We're going to have new records when the defense is in the driver's seat, guys. Yep. Oh yeah. Oh wait. Yep. We're racking them up. So the airbag, you have to hit something at a certain, you can't just tap something and the airbag goes off. So I get that. And I do believe that Dr. Welcher did testify that none of the devices would actually show a actually impact, usually with the pedestrian, that the sensors are all around the car and actually are geared more towards vehicle to vehicle collision. But I don't understand here. They did the systems themselves do pick up impact, but I think he means, did it show any? Well, Rody, this is a new expert they had on ARCA for last the first trial rather. And they are the accident reconstruction specialist, that company. These are the three top, we got Aperture, ARCA, and Delta V. They are the top three in the nation, and they've all been in this case. But ARCA, if they are testifying, there was some stuff back and forth about discovery. And since it wasn't met, like, I don't know, they are on the list to come and talk about their experimentation. It does not seem that this witness was there to do any accident reconstruction. He was actually there to analyze the data from the other experts, period. Because everything he's talking about, he's just pulling from their stuff and analyzing their stuff. And it's all about, he's an ERD extraction expert, apparently. He deals with the ERD for that company. Even though he is, as he said, still listed as an accident reconstructionist, he can do all of that. But for this purpose, his job title, he is the department head. He is the head of the ERD department at that company. So. They're curious. I wonder. Well, the problem with the ARCA witnesses in particular, Rodent, along with what you're saying in the chat about their conclusions and all, was that it came to light during the first trial and also during the voir dire before the second trial, during pretrial motions and hearings, that ARCA was only given information from the defense and never got all of the evidence. Never contacted the prosecutor office or anybody else, just got everything from the defense, in line with being a paid expert. I mean, there's nothing wrong with that. But when it comes to independent analysis, like what Dr. Welcher did, and I'm not like trying to set one expert up against the other, but the glaring difference is Dr. Welcher took the information from everywhere. And he said he wanted he was hired for his conclusions, as he said, and the prosecution said, to be independent of anything. To be, in the first trial, the defense presented ARCA witnesses as neutral because they were hired by a third party through another investigation, which has now been disclosed as the FBI. They worked for them, and all of their testing was done under their advice, and now they're just testifying to it in this trial based on, the defense asking them to come in. So the whole thing about them being neutral, but it was later disclosed that they actually paid for that testimony, and that there was talks between Alan Jackson and representatives of that company. I'm keeping all their names out of it because it's not my intention to disparage anybody. Well, the defense gave incorrect, misleading, or actually left stuff out when asked in February directly if those expert witness was still neutral or that they had hired them. They said they didn't pay him. Lo and behold, it came out that last July they did pay them. There was a canceled check. There was email that the Commonwealth got through the FBI, through their correspondence, through a FOIA request that showed that ARCA representatives had been in touch with Alan Jackson. And that's why the signal reference came up yesterday, because when asked for all the discovery, as the Commonwealth and the court now wanted in regards to those communications, if they're going to bring those witnesses out, there needs to be a voir dire. We found out that they communicated through Signal and deleted all of their correspondence besides the emails that were sent, which were damning enough, actually.
Okay.
But
Mr. Jackson, how much longer? I'm just trying to figure out.
I'm wrapping it up, Judge.
Okay.
It's not going to be long. A few more questions.
I'm not curbing you in any way. We just
Understand. Respectfully, it won't be very much longer. You reviewed the tech stream data, otherwise known as the triggers, for the entirety of Ms. Reed's vehicle, correct?
Yes.
How many trigger events did you find in the life of the car?
Not counting 1162-2.
Let's stop there. Right.
Prior to 1162-2, there were 19 prior events.
And 19 total events, correct?
Correct.
And how many collisions were clocked by any recorder on that car?
None of the events were triggered by a collision.
and no one testified to that. They said that
And
there was a backup.
last question, do any of the tech stream events or do any of the data that you've reviewed either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time? Objection.
ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by a collision.
Thank you. May I have just a moment, Your Honor?
I'm ready to be finishing up. I'm hoping that I get some understanding of what happened here by the redirect, but we'll see. I will admit to being lost.
That's all I have, Your Honor. Thank you.
Okay. Jurors, we're going to take the morning recess. There's some things that we need to do with the lawyers. That we'll have you come back at 12.
So then they're going to do the morning recess now.
Can I see counsel at sidebar to save us some time, please?
Oh, I'm going to count that one couch. All right. So we got 6, even though it's break. Wow. So we'll have redirect from Hank Brennan or Adam Lally. I don't know who. At the I think because it's Dr. Welcher, it would be Hank Brennan. Yeah, hitting him was below the threshold to back. It's exactly what they said, right, Rodin? They said it would not register because of the car was going 24 miles an hour, but they couldn't say it was at 24 miles an hour when it hit him, but it was at least over 8 miles an hour because, you know, it depresses down at 75% and was doing 24, but it may not have stayed at 24 the whole time. They couldn't say, because remember, the event that's captured is just a small amount of seconds of it. She's definitely cool enough to join the Purple Club. It's a new thing that YouTube does. It's called Community Leaderboard. It's a tab at the top called Community, and it's a leaderboard. See, Maggie's number 1 right now, then Rodin, and then Jin, and it's based on how much you interact with the chat. You are currently at number 4, so you're not that far off there. You do a couple more comments and you'll probably bump one of them off and get a cute little purple thing next to your name there. Mandy. No, yes you are. Don't let Rodin say Rodin. Take it back. Take it back. send her some love. Like, take it back. Oh gosh. I have to mark sidebar 6 so that we have a record. And then the jury is on break. Then the court will go on break. Yeah, they YouTube does this stuff, like, they don't tell us about. I mean, I guess maybe they do, but I didn't look at whatever notices there were about it. But it's just something to interact with the chat, to give you guys, some incentive to talk to me more, Yo, boss, you wanted me bump them off. I don't know. Well, it's based on interactions, and it doesn't count me. It doesn't count the channel owner, the person that has the yellow banner. So Pete was here this morning, Mandy. He brought coffee. If you're listening, Pete, thanks. It was nice. It was a drive-by coffee. Nice to have a morning break of 40 minutes. You think it's going to be 40 minutes? It better not be 40 minutes. Maggie, don't call the devil. Shh, shh. Don't say such things. Although it's funny because it's probably true. You don't think it can? Oh, yes, it does, because you're number 5. I just saw you got a purple. You lie. Moderator liar. It just had to prove it to you as soon as you said it, right? Okay, we're officially on break now. Well, at least the rest of the court is. The jury already left. Oh my gosh. That's too funny. We all know Claire doesn't need the crown to be our purple queen. Aw, wrote it. What, that's sweet. Okay, anybody's got stroking the bear on their bingo card, that counts. That was nice. That was very nice. It also was when Pete showed up with 3 cups of coffee this morning in the chat. Like, that would also count. Okay. Did she say 12 o'clock? Maggie, she did. I didn't catch that. Thank you, love. I'm so glad you told me that. Wow, that's a long break. What are we going to do for 30 minutes or 40 minutes? She said 12 o'clock? Wow. Because don't they normally go to lunch at 1? Why such a long break? Wow. Did she say why, Maggie? Oh, geez. You heard it. I'm glad you're saying something. Like, and I was joking before. I hope you didn't take offense. I did not hear that. The socials are a little confused too. They all think that this witness is actually confirming a lot of Dr. Welcher's stuff. There's also a lot of talk on the socials in regards to this witness, since it went against both Burgess and Welcher, and those were actually crosses by Robert Alessi. There may have been some type of incident because it looks like he was benched from it. It would have made sense that he actually, since he was familiar with the other questions and angles. There's an account that does behind the scenes things in regards to the Reed camp. That he says that at the hotel there was a bit of an altercation between Karen and Robert Alessi, in that he also made a comment that that big thing about her leaving the courthouse on her own yesterday with no help was her idea. She wanted it to be a sign of strength, the accused going against the system, going out there on her own, her against the world. Only not a single reporter asked her about it. Nobody really commented except for how sad it was. They actually took the other route and said, well, maybe nobody wanted to be seen with her because she pissed them all off during the day. It didn't come off the way she wanted, and she was in a very foul mood for the rest of the evening from what this account says. Like, in this account, I'll be honest, it looks like an anon account. It has a funny name. It does have a blue check, so it's been verified as a real person. But it doesn't say who he is. It talks about stuff from the Reed camp, like they have inside information on certain conversations, But since there's no way to verify them, I can't sit here and say that everything is absolutely true. I just found it interesting as another take to what I was saying yesterday about, what I was saying in the Discord about her leaving on her own yesterday. I thought that was all in the way she was answering the questions as if she was in charge of the defense team, as far as who would be the next witness and how long things were going to take. But fair point. She's been talking like that with all along, like always answering, because she is very involved. They have meetings every day. She is very involved, but not so much as it's been the last week where she's actually interrupting people on the podium with questions and all. And apparently that's what the argument was about. Is that all it means, Jen? Because when I got my a subscriber or a supporter actually paid for my blue check, and they wanted me to be verified on Twitter, so I couldn't get bodied or impersonated. One of the reasons I won't change my avatar, or I try not to go too many chats that I'm not moderated in, because people will try to pretend that they're you, and I had a problem with that before. Well, they actually, long story short, they actually paid for it, but I did have to do some verification for my account. I had to verify some things. You do have to pay, and then they go over your account. It takes a day or two, and they see if you qualify for certain things or whatever. Maggie says, I think this witness just doesn't want to go against other experts in the industry. Well, he does work for one of the top three. They all work together. I think professionalism is required. I also think that there's not anything definitive. Like all three experts said, it's all, there's nothing definitive. They're just narrowing the window. I think that Dr. Welcher was very careful to say that. He said he can't say exactly what happened, but he didn't come there to say what didn't happen, which was his answer to why didn't he test all these other theories out, and take other information into consideration, like how many people were inside the house and stuff like that. Part of what some people are saying was his Starkey remarks, but I actually found them to be just genuine and honest and direct, in kind of like in engineer speak, cause and effect, probabilities, things like that. That's kind of what this account was alluding to, and that the reason Bob Alessi is not actually doing the direct today is because he said to Karen, well, those were your questions, because she was berating him for his performance. He said, and that whole voir dire was apparently Alan Jackson's idea last minute. And they said that was both of you. Like, that's like, those were Alan's questions, and that was your direction on what to take. Like, so he threw it back at her right in her face, and I think she didn't take it too well. At least that's what that account is saying. I have no idea if any of that is true, and I am not going to sit here and act like it is. You know what I mean? Like, as Groucho Marx said, I don't want to be a member of any club that would have me as a member. Jen, I did join a club though. Apparently I'm part of a group, a little, casual group on X who are fans of Hank Brennan's tie and his socks. Because I do look to see what he's wearing. I do love a good tie. I do. I like smart dressed men in, suits and lawyers. Well, that's a smart dressed man in most cases. But I really love a person who has fun with their socks. I think a man who puts on a 3-piece suit and then has a little fun with those socks, man, it shows a little spirit, And so he has had some wild socks on. Like, he had this beautiful silkish looking, I don't know if it was satin or silk. It was like, it had a slight sheen to it. I can't really tell the material, but it was like a gray on gray tonal with herringbone pattern like in it. It was just gorgeous, and it offset that dark suit so lovely. And then he wore these crazy red and blue Argyle socks. At least that's what they said, because I didn't get a picture of the socks from yesterday. You're just a fan of the Fantastic Fan. You're in the fan of fan club, like we all are over here. Exactly, Maggie. And I think that's what we said. What we have here, we have an incident that has absolutely no witnesses and no definitive data. Just, you have to take okay, there's such a thing as totality of evidence. I know I'm going to get a little technical here. Sorry, not sorry. We got to kill 30 minutes. So let's just play. There are theories and then there are theories, okay? And the only way to get rid of a multiple theory case where the possibilities are just, there are so many, okay, is totality of evidence. You've got to go with the theory that fits the majority of the evidence, not one piece of evidence or two pieces of evidence, the majority or all of it. And I think that that is what the Commonwealth did. By these experts not being exactly precise and not claiming to be, they have narrowed the window down to put Karen and John in the same place with a backing up event right about when the phone stops, okay, in this area of where the body was found. Now, we also have tail light pieces in his clothing. Tail light found all over the scene. Pieces of tail light. We have broken glass that Karen admits herself was in the car that the video shows him leaving with from the water hole. You did send some. Oh, thank you, Mandy, for the socks. But come on, totality of evidence. When you look at it, I know most of you kind of have been agreeing with some of the things that I have been saying all along. Oh, man. I love both of those so much, Mandy. I do. And because of the curse words on them, I can't show them because I have enough trouble with YouTube right now. Do you know that YouTube has been taking every single one of my videos and making them yellow for a day or two before they release them? It's bad enough it takes like sometimes more than a day to upload it from live so that it's actually in the algorithm. But now Now they're actually reviewing it all because it's a trial. I guess it might have been the P. Diddy stuff that really, like, they definitely fought me on that. And then, I had the audacity to do the 50th Law, which talks a lot about gangs and drugs because it was written with 50 Cent and Robert Greene. And it talks about power. But, I think Recker and I do it in a respectful way, not to condone those activities, but to take the life lesson and apply it in a way that everybody can use it. I think that was the approach that we both agreed we wanted to and why we wanted to do it. But it took a lot of convincing and a lot of emails with YouTube to convince them that's what I was doing, because they just see the 50th Law, the 50 Cent. They were like, nah, girl, no, you can't put that there. So I had to show them that everybody else had it out, and it can be done respectfully, and we're not condoning anything or talking about the violence, and I did. And so that is not getting yellowed now, but everything else on my channel is for at least more than 48 hours, sometimes 72 or more. So I'll sit there. This is the funniest thing. I will sit there with 42 views, which are the views usually that happens while I'm live. Okay, everybody knows that this channel has always gotten more views after the fact. It's just the way it is. I don't have a lot of people here at the moment all the time. But I get steady views every day. And so normally I would go from 42 views, and the next day it would be in the hundreds, and then it would slowly climb. Now it's 42 goes to 50, 60, and then there's hardly any movement, and then boom, then all of this movement happens when it hits the algorithm or the 70 or after 48 to 72 hours. It's crazy, and it's happening consistently every trial day, one boom by boom by boom. Yeah, it's crazy. It is completely ridiculous. It only happened after I hit 10,000 too. When I was smaller, they really didn't pay attention to anything. One 100% of statistical comes from the same place, pulled out of your Jen, stop it. Yeah, I think so. And also there's a lot of traction. There's a, the views are decent. I don't like to pay attention to that kind of stuff too much because I want to stay the same. But I think you're right. I think that there is more scrutiny on it. Because there's more traction. It does get, and plus the amount of content I'm putting out would automatically trigger the algorithm a little bit. And so I think you're right. I think I just have to go through this process. I don't really mind as long as the video gets released out there eventually. I don't really care when, although I do feel that people would like to see it when it's more timely. Maggie says, when I drive, I can feel if I tapped in something in our driveway because my husband collected so much stuff. How can she not know she hits the... Well, you see, as I think Brennan said in the argument this morning, he feels she does know, but she has said it in lots of different ways throughout these interviews. Sometimes the truth has a way of coming out. She talks about, did I hit him? She literally even said, did I bump him in the knee, right where he has an injury? And I know she knows of all the injuries because she's been paying attention, and she went through the first trial, and then she's been doing all this talking. But why would she say all of this stuff? Yeah, she knows she hit him because she said he didn't look mortally wounded. And yet on the other side of the coin, that could have been when she showed up in the morning too. It's a matter of what she was thinking. But the point is, she says all these things, and it's the first thing that comes out of her mouth. So it does look, I don't blame the Commonwealth for going after consciousness of guilt, because when she puts it out there like that, it's not in there with all the context. It doesn't come with all the stuff she's been thinking before. It's just a statement. And it makes her look really, really bad. I mean, really bad. I think she did have a come to the moment, so to speak, Maggie, in the morning when she got up. Because here's the thing, what really sticks out to me is the things she didn't do. She's worried he didn't come home and that something happened to him, but she never called the hospitals. She didn't call Jen McCabe and say, what time did he leave 34 Fairview? Matter of fact, that is a question she never asked her in all the time they spent looking for John and talking on the phone. Never asked him if she saw him inside. Never came up. Yep. Oh, are you doing an analysis on my channel now, there, Mandy? you people are attention to it that I do, but yeah, I mean they're decent, yeah, and they're in within 4 or 5 days of me uploading, right? Because like it does take time from when a live ends for it to go through the analysis process over there at YouTube before it actually becomes a video in public, okay? And so it's like in a different state, even though it was seen. You'll notice because the chat is not there, that it hasn't been cleared yet. Okay. And so it usually takes anywhere, it could take up to 24, sometimes 36 hours to do that. And I will admit, one of the reasons that I now do 2 different streams a day is because the longer ones that are 6 hours plus could take 48 hours to clear, and often would get held from the algorithm because they're so long and get really poor views. I get better views where it being only an hour or so here and an hour or so there. And then the time stamps help too, because people can skip through the breaks if they really only want to see the information and they don't want to hear me talk. They can actually, I give them the opportunity to do that by skipping through using the timestamps. And so I've been getting better views than my last trial. I've learned. I've done a few of them now, all the way back to Amber Heard, ending with the Murdaugh trial and all. None of that really got substantial views. It was fun, and I wanted to do it because it's interesting. I don't do it for the views. I do it for the experience and the interaction, and because just I like this lawyer stuff. I love looking inside the courtroom. She does. Jen, that's true. Mandy says she notifies me about my milestones before I even know. She has been the first one to tell me on multiple occasions. Do me a favor, Mandy. Let me know when I hit 15, because that's the next time I'll do a celebration or stream. And I'm actually going to let everybody choose. Like, I was thinking about that. One of the ideas I had is I'll actually, if they want, I'll actually make an idiot of myself and go out there and learn how to play a video game or something, or do some kind of game or something, or we'll do whatever, or we can have everybody come up, but that, like, to me is a little uncomfortable because it's like everybody thinks they got to praise you and stuff like that. Like, I think, don't get me wrong, I think it's great. I do work really hard at what I put out here, and I want it to be good for everybody. I want it to be stuff that I will never regret doing. Like, I do think about it, and I do try to do my best in what I do, but I still want to have fun, because after all, it's a hobby. In HOBBY, not a job. It's not a JOB. It is a hobby. And I do spend a lot of time on it because I no longer work, and I have time on my hands, and I like it. I like it a lot. Like, I wanted to have these conversations out here. I know that's how your brain works, Mandy. Just let me know. I guess it's good though, because I will say it is a thrill to have you slide into the DMs and tell me what they are, because you do it in a way of celebration, like with joy for me, and that feels good, because so many times, especially out here on the socials, and I know you all are aware of this, and I'm not saying anybody here is guilty of it, but so many times you're out here on the socials, and as you start to have things going your way, people get like petty about it or start making assumptions about you, like, oh my gosh, she's going to change now. Like, oh, this, oh, that, start talking about stuff they don't know about, And I don't want to change or be influenced by the numbers, but it does feel good to have some recognition. It does. I mean, of course it does. Like, it's a no-brainer. Of course it does, So it feels good when she comes into the DMs and tells me, oh, by the way, you hit 10,000. I'm like, what? I have to go look because I try not to concentrate on it. I really do. I know, Mandy, because we didn't have enough time to talk on the phone anymore. And we did it for Amber. We did it for that Amber Heard trial. That was one of the best experiences with you, girl. Remember, I would be all day with Ranty, and then you and I once a week would do an evidence examination on all the stuff we knew outside of what was going on in court, and we would pull it all together for everybody. Those were some of the most fun, entertaining weekly ones that we did. And they helped me stay strong because a lot of people wanted me to join their channels to do this instead of keeping my own. And I just decided, nah, I really wanted the freedom to do it my way. So that there's always a bit of hype and a bit of like sensationalism. We all here talk a little bit of snark and a little bit of smack here and there about stuff to do with the trials, but I never want to get on the hype train in just over sensationalized. I always want to be respectful of the victims and their families and not carry it too far. I never want to worry about like what's going to make the most views, what's going to make the most clicks, or even about the monetization. When I say something about my video being in yellow, it's not because I'm worried about the ads. I have the least amount of ads you can possibly have. Like, I have the setting down to the one that's required just to keep the monetization for memberships. So, like, I'm not really concentrating on any of that. I mean, it is part of everything. I mean, I'm on YouTube. I'm a YouTuber. Like, there's no denying that. But I really try not to focus on all of it. My celebration isn't having the conversations with everybody. That's my biggest joy. And I'm really happy about that because of the exposure that we're getting, Mandy likes to. Not a job, it's a hob. Is that my new tagline? It is now, Mandy. Yep. Not a job, it's a hob. It has been all along, but these conversations on true crime and that stuff taking off has allowed some things that are close to my heart to become a little more popular, like Black Mirror, or my readings on that we do, the project we're doing right now with so many different communities and readers from all over in doing the Hitchhiker's Guide series of Douglas Adams. We're on the 3rd book, and that is getting numbers too. And that makes my heart sing because these are passion projects, things that I only put out there because I liked it. I didn't think anybody would take off. I was invited on the Proctor and Paul show. Yes, I'm sure they'd be glad to have me. because Turtle, I've been known to use the C word. As a matter of fact, there was a Christmas holiday stream where somebody just kept paying me to say it. Like, I think I said it 124 times on somebody's stream or something like that. It's probably an exaggeration, but that's the number they were tossing around. Those were the days. I'm not really known to not curse. Those were some good memes. Rocket Couch every day, Mocking Media would make like a meme about what was going on. In some of my favorite, Mandy, what was the name of that jovial friend of the artist guy? Oh God, he was like so Jersey too. He was kind of gangster. Isaac was the best. I mean, some of the memes that we made and little skits and stuff. Oh my God, Rocket Couch, you're right. The memes were incredible. I mean, we just had fun. And you know what? a lot of you that are in the chat were there for the beginning of my trial coverage on YouTube. Yep. The make a pint. Exactly. Oh, I like the bruise kit. Like it was meant to cover it up, but it was like purple. Like, yeah. But it had purple shadow in it. Somebody just recently commented on that short that I did about that. They said, why is she using a compact with heavy purple in it? I said, exactly. That's not, it's to make a bruise, not cover a bruise. Yeah. Oh, Maggie, that's right. You did watch me on the shows. I loved working with Amy. I loved that Sunday show with Amy so much. We got to talk about, things, real conversations. Wouldn't you agree? Like, just about subjects that sometimes people don't want to get into, and I really enjoyed it. Yes, they were taking his candy off his desk. Johnny Depp's, yeah, always had the candy. He had to have special permission to keep snacks on his desk because you're not supposed to have food in the courtroom. Mm. Mm. That's right, Maggie. I recognize the flower, the sunflower now, and I'm so glad that you stayed with me after that. I would do something with Amy again in a heartbeat. She was so much fun to work with. What a bright, intelligent woman with a good solid perspective on things. And, it was a lot of fun. And we always tried to keep our humor too, you know. Yes, we talked about Tate. We did the red pill. We did Elon Musk. We went against the fro. And sometimes we went against like the guys too, because they didn't want us to get too serious. And we are like, sorry, serious is cool. Like I'm a nerd. I am a nerd. To me, serious subjects are cool. That's what gets me going. Like, sorry, not sorry. Can't apologize for who you are, right? Yeah. I love doing the Starsky show too. I really liked working with Starsky. He's a really great guy, and I thought that was a good cause, and regardless of some of the disparaging remarks I got in people that have left, because I do still support that cause. I do, I don't stream on it, but I definitely support it. It is what it is. Two sides to every coin. Yeah. Hmm. It was fun. Mandy, I loved doing the Britney Spears one with you recently too. That was fun. We should do, I know you've been really crazy busy, but you should think of something fun we can do. Isaac Baruch. Yes, he's an artist. He's a pretty good artist too. He does like comical views of celebrities. He does like, it's kind of cartoonish, but it's not. Like it is exaggerated and all. It's modern art for sure. Mm. But what a genuinely good-natured person, right? With a good heart. Like he was the best on the stand. Like, I don't think the new Lori Vallow Daybell, I'm gonna say Lori Daybell. I know that she's charged under Vallow, but let's just say Lori Daybell. That I don't think that this actual next trial is going to be very amusing. Already the second hearing, she's so testy with Judge Barisky, and he's trying to be so reasonable, spent so much time trying to straighten out her misinformed take on what the law said. I don't even think she's listening to her advisory council very well, because I'm sure they're giving her the information, but she hears what she wants to hear. Like she was arguing all about aggravating factors and about whether something was a dangerous event, like a dangerous crime. And if you're convicted already, then yeah, yeah, obviously. And they told her that it was a state law now and it had to be done by the jury instead of the judge. And she still was like arguing for some kind of hearing that she's not entitled to. And he spent so much time trying to help her out with the information so she wasn't disillusioned and she could spend more time doing what she needs to do, like following through with discovery requests for her witnesses so they can actually take the stand. Like, she'll go in on these small details and yet doesn't comply with the actual obvious thing of discovery, acting like it's a shock that she has to turn over information to the state. She still is doing that. Like, it's, oh boy. Anyway, next week, they're in jury selection process. Next week, they're supposed to have their first witnesses. We'll still be here with Karen Reed. I'll be reporting on it, though. Definitely. I do want you all, if you want to follow it, like at night, or if you're not here with me and you want to, please give East Idaho News a view. Please give Nate Eaton a shout. I just did a Twitter post for him because when it comes down to following those cases, he's been on it from the start. But what I appreciate about it is, like, yes, he's got a YouTube channel, and yes, he's making his money, he's a reporter, and this is his thing, right? But it's the respect for the victims, the support and the platform he offers the friends and families of all of the victims in these cases is just astounding. Like, I just want him to get the flowers, Mandy, I just posted a video on it. Jennifer Green was the judge. That's the first part of the video. And before I was done, we went through jury selection. It was at the end. There was a mini hearing about aggravating factors. I posted it. It's in the Lori Vallow. It's probably the second or third video on my channel right now, but it's in videos, not live stream. It's an upload. Hey, Sean. Good to see you, love. But yeah, the whole thing's there. If you saw the Jennifer Green, if you saw Judge Green's hearing, then at the end of jury selection there was a mini hearing, and that's when we get to see Lori Vallow in entitled goddess mode. Man, she is really lit at the judge, because she lost. The judge has not been removed from the case. Yeah, I thought she had everything lined up for her witnesses too, but she hasn't turned over some discovery. There's still some issues. Like, she sent the subpoenas out and everything. I will say that, the victim in this case against Lori Vallow, Brandon Bordeaux, he's been on Zoom for all of the meetings, and he is going to testify. He is on the witness list. Well, man, she's frustrating. But anyway, if I'm not, covering it live, I think Nate, just due to his relationship with Kay Woodcock and Ryan, and Kobe Ryan, and the sisters, the relatives, the friends, Charles Vallow's family, the Tylee's aunt, just the support he offers them. He's got a great relationship with all the law enforcement. There's been, several of them have come onto his channel. He treats people with respect. And, even though it's fun and he is a reporter and he has to go for those kind of questions, the sensationalism isn't over the top. Damn, it's what he does for a living. I get it. But, I just wanted to give him a shout out because the endurance alone, like, he's in Phoenix now, to cover this. Mandy, do you want me to grab you that link since you're working so you can look at it later, or are you going to go find it? Or maybe you already watched that hearing when Nate put it up. I think I put it up a couple hours after Nate. I like that turtle crope afternoon, Jean. You know, this is a problem with being pro se. If you don't have the good understanding of the law, or you don't listen to the advisory council, or ask the right questions, or listen to the answers that come back, or at least about the in Arizona what the protocol is and everything. I mean, she actually sounded like she was shocked that she had to turn over what her witnesses were going to say. She said, "What do you mean? I got to tell them about my case?" He said, "Just like the prosecution had to tell you. Yeah, they sent you all the discovery. You have to send it to them." And we're talking about Lori Vallow, even though we're in the Karen Reed trial. Our 40 minutes have passed, Maggie, and where are they? This is ridiculous. And why a 40-minute break if we're going to just go to lunch? Maybe they had something. Maybe there was something she needed to read. Remember, she was asking, Miss Little for some document or whatever in all of this stuff. So I think maybe she's going through everything. I do know the Commonwealth has filed motions to keep the Proctor text out because since he's not going to take the stand, it's hearsay. And he's objecting to the witnesses that are there to, they think that they can get around it being hearsay by calling in a witness who's in that text change, but they have to call a witness that's relevant to the case. They have to prove relevancy to get it in there. It's going to be a little bit of a thing between the defense and the Commonwealth while they work all this out. Now, she did say she didn't want to discuss it until the two attorneys had talked because of the firing of stuff back and forth, but we'll see. That should be interesting because if they can't get that, I mean, I know they want to bring that in. That's the linchpin to, like, Proctor arranged everything. He hated her so much that he caused a conspiracy. And he must have worked with Brian Higgins, who is so in love with her, that they worked together. And then they got Brian Albert involved because, they were going to lure him to the house. And, like, because he's so high up in command and everything and has such respect, it would be easy for him to get everybody to just cover it up. 140 people involved in law enforcement and the fire department, they're all conspiring against Karen Reed for this because he was beat. But, totality of evidence. There's no tracks in the snow. They're back. Do you think they're going to open with a sidebar?
Back in session, you may be seated.
All right, Mr. Brennan. And Mr. Disogra, I'm going to ask that you keep your voice up because we're going to try and keep the air conditioning on. And the fans, it's a little stuffy in here. So if you just speak directly into the microphone, that would be great.
Not a problem, Your Honor.
Thank you.
May I proceed?
Please.
Good morning, sir. Good morning, sir. Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022? Objection.
I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus never got in a collision before?
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Ms. Reed's Lexus never got into a collision before January 29, 2022 or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, are you?
I think you threw a double negative in there. Can you just clarify what you meant? Yeah.
You are not suggesting to this jury that Ms. Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text stream to suggest a collision.
Specifically, none of the events were triggered by a collision. That's
Text stream data can be triggered by a number of different things other than a collision. Isn't that true?
correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it wasn't triggered by a collision, it's never going to be triggered by a collision ever on text stream data.
Not the collision in and of itself, correct?
Right.
Mhm.
Right. So there's other things that will trigger text stream data,
Correct.
like sudden acceleration.
The only acceleration trigger that I'm aware of on text stream is if there's a large acceleration during what Lexus calls a PCS, or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about text stream data? Do you know a
Ouch.
lot about text stream data?
Yes.
And you're saying that if a car accelerates over 30%, in and of itself wouldn't initiate
Copy
the trigger?
date.
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you,
I'm allowing this.
if someone accelerated Ms. Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers there's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, is that, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium to high is what they put it.
Do you have a number? Do you know the actual data on what percent of pressing the accelerator on the same Lexus as Ms. Reed's would create a triggering event? You know.
Off the top of my head, I don't know the exact percentage down to this percentage point, no.
There is something different than the text stream data. That's the EDR data, correct?
Yes.
You would not expect, it would be abnormal for the EDR to register data based on a side swipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it?
Objection.
I'll allow it.
That would be abnormal to register that data into the EDR, wouldn't it?
I don't know if I would use the word abnormal, but I would state it that there's a minimum threshold to record in the EDR, and a pedestrian impact generally wouldn't meet that.
I'm sorry.
A pedestrian impact generally wouldn't meet that, but I don't want to make a blanket statement as if it's always the
You're
case.
saying it would meet that?
Would not.
Would not. Okay. And a side swipe or a clip has less force and impact than a head-on collision, depending on the speed, correct?
Generally, yes.
When you are discussing the triggering event, that is the moment that something registers to the car to capture data in the text stream, correct?
Correct.
So if I was to suggest 30% of depressing the accelerator pedal would cause a triggering event, would the triggering event be when it reaches 30%?
Yes.
The event data captures potentially part of an event, doesn't it?
I think we're into semantics a little bit, and I think it depends on what you mean by event.
Exactly.
Because previously we'd been talking about an event as the data, but event can mean a lot of other things.
If an event's only 3 seconds long and 10 seconds of data is captured, then the data will capture more than the event, correct?
Correct.
If the event is longer, 15 seconds, 20, 25 seconds, and the data is only captured for 10, the text stream data only captures part of the event.
Correct.
Fair to say?
Very fair.
So when you're looking at the data, it doesn't tell you about the entire event, correct?
The data only tells us about the window of time the data captures. There's no way to know beyond that from the data.
All of your equations and pluses and minuses and graphs you're talking about deal with the 10-second text stream data that was captured, correct?
They deal with event 1162.2, right, and the 10 seconds it's comprised of. Actually, they really just deal with the end of the event. That's what everything in the Aperture reports reference.
Fair enough. But it doesn't deal with anything that could potentially happen after those 10 seconds, does it?
No.
Or anything before?
No, it does not.
The triggering event is spot in the middle, it captures 5 seconds before, 5 seconds after.
Approximately 5 seconds. It's not exact.
And you would have to look elsewhere for evidence to know what might have happened before. Yes?
Correct.
And you'd have to look elsewhere for evidence to see or determine what happened after.
Yes.
Do you know at the end of this triggering event, that 10-second window of data, do you know what happened with the defendant's Lexus after that 10-second of data?
No.
You have no idea, right?
I don't.
Okay. I want to just ask you some questions about your background and then leading into this case, if I could. You have a bachelor's degree and a master's degree.
That's correct.
You've worked for your company for some time.
Coming up on 13 years next month. Correct.
You've advanced through the company.
Yes.
You presently are the director of engineering.
Yes.
Are you ACTAR certified?
No.
What is ACTAR?
ACTAR is a body that basically offers a certification in accident reconstruction.
Do you offer services as an accident reconstructionist?
Sometimes.
And you have been hired and come into court and offer opinions as an accident reconstructionist?
In the singular time I've testified in court, it was not specifically for accident reconstruction. It was data analysis.
Okay. You continue your education and you go to a number of different trainings and seminars as well as teach, correct?
Regularly.
And when you regularly go to continuing education, you have quite a bit of continuing education that you've been through, haven't you?
Sorry?
You've been through quite a bit of continuing education.
Yes.
You focus as part of your specialty on EDRs, don't you?
That's correct.
Event data recorders.
Correct.
In fact, when you promote your services, that's one of your real specialty, isn't it?
Correct.
And it's something that not only are you schooled on and you go through continuing education, you're well published, aren't you?
That's correct.
And in your publications, you speak primarily about EDR type information.
Yes.
And that's something you are well skilled in, isn't it?
Yes.
Now, forensics or data forensics is a wide field, isn't it?
It is.
And you can do some things or many things in it. But oftentimes people specialize in parts of data forensics, don't they?
Generally, yes.
Well, speaking of you, you specialize in EDRs, true?
Yes.
There is a difference in different subspecialties, isn't there?
In general,
Yes.
yes.
Okay. Now, are cell phones, is that a subspecialty in digital forensics?
Yes.
Is that something you're a specialist in?
No.
iPhones, are you a specialist in iPhones?
No.
Have you ever taken any specific training on mobile forensics?
No.
Have you ever written any papers on mobile forensics?
No.
Hey, have you ever promoted yourself of having any type of subspecialty as an expert in mobile forensics?
Never.
In any of your continuing education, and you have a vast amount, have you ever taken any classes or seminars in mobile forensics?
No.
Have you ever taken any class or study about variances between infotainment systems and mobile forensics?
Classes? No.
Have you ever attended any seminars? on variances relative to mobile forensics?
No.
Have you ever testified about variances in mobile forensics before you testified in this court today?
No.
Have you ever published anything to do with variances in mobile forensics?
No.
In this case, you had an opportunity to review a number of reports from Dr. Judd Welcher, yes,
Yes.
and Mr. Shannon Burgess.
Correct.
In reviewing those reports, you've offered your opinions and analysis. Did you ever engage in actually any efforts or study in this case to obtain data?
Could you maybe clarify what specifically you're asking?
Yes. Did you ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
Did you ever test Miss Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
Did you ever do any actual testing in this case?
No.
And so your role is to look at other people's work and offer opinions and criticisms, basically.
And provide some clarity to the work, but generally, yes.
Clarity for who? Who asked you to provide clarity?
My clients in this case.
You what?
Mr. Jackson,
Okay.
my client.
Did you ever speak to me?
No.
As an expert, when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? You ever write a report?
Yes.
And you've seen reports in this case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess,
Correct.
report by Dr. Welcher,
Also correct.
reports that you're critiquing, right?
Correct.
Did you see Ian Whiffin's reports?
I did not.
How about Jessica Hyde? Did you see her reports?
I did not.
You were asked to consider information from Mr. Whiffin's report.
No.
Well, you were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report, so I started my analysis at that level.
So none of the information did you actually personally go and vet or analyze or make any determinations about? You're just critiquing written reports.
Correct.
Well, as an expert coming into court and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it. And number two, the extent of my work beyond building the PowerPoint was just basic addition, just adding numbers together that already existed in the Aperture reports. So there wasn't a tremendous amount of complexity to what I engaged in.
What about your work product and your calculations? Did you do all this in your head, or did you type it out and go through a computer program? How did you do it?
I used a calculator for most of it, and the tables in my PowerPoint were generated in Excel, which has some calculation capabilities.
Were you ever asked not to write a report?
No.
You
Okay.
had provided an initial PowerPoint,
Yes.
and then you received information from Mr. Burgess,
Yes.
and then you added new slides to your PowerPoint.
That's correct.
Mr. Burgess's report was May 8th.
Yes.
You provided your PowerPoint on May 25th.
Correct.
Did it take you that long for the calculations between when you got the report and May 25th to put together the new presentation?
No, it didn't.
Why did you wait until May 25th to provide the new information?
That's when I was asked to do it.
What do you mean by that? I just want to see what the date is today. Today's the 30th. When you finished your PowerPoint on May 25th, did you send it to the defense on May 25th?
Yes, I did.
They had a copy of your PowerPoint on May 25th. Don't be shy.
No, I'm pretty sure it was the 25th.
So sustained.
Yeah, if it wasn't the 25th, it would have been maybe the day after, but it's dated the 25th. I'm almost positive I provided it on the 25th. Yeah.
There's no reason for you to hold on to it for a couple of days.
No, I think it was the 25th.
Do you know what was provided to the Commonwealth that report?
No, I don't.
In the 25th, the report that you provided to the defense on the 25th, it had new information in it, didn't it?
It had the information from Mr. Burgess's supplemental report. That was the additions.
Why did you wait until the 25th to put it together?
That's when I was asked to do it.
Who asked?
My clients, Mr. Jackson,
He said, please have this on the 25th.
we had a phone call on the 25th and discussed Mr. Burgess's supplemental report. During that phone call, he asked me to update the presentation, and I did so and then provided it.
How did the date of the 25th come about? Why the 25th was the date provided?
That's when he requested it. I think it was a Sunday, actually.
When you first got involved in this case, it was last fall,
Correct.
and at that time, you received some information that Mr. Burgess wanted to look at the text stream data or the different modules on what you later learned was the defendant's Lexus, correct?
Correct.
There was a proposal from Mr. Burgess. Mr. Burgess wanted to go back to the car and look at the modules to try to download more information from them, correct?
Correct.
And you then got involved to look at what his request was, the procedure that you wanted to follow.
Yes.
When you did that, were you given any materials about what had happened before you and Mr. Burgess both got involved?
I don't recall specifically, and I don't think so. I think I was just provided the notice of testing that was to be done.
Well, you ended up drafting an affidavit.
I did.
And in drafting an affidavit, you pointed out some oversights of Mr. Burgess. Did you?
I did.
Determining the oversights required some study of actually the data and the information that was available, wouldn't it?
It would.
So can we presume that before you wrote the affidavit pointing out the oversights, you had looked at other materials?
If I recall correctly, the notice of additional testing from Mr. Burgess contained attached to it a whole report by him documenting why he thought there was an inadequate initial acquisition, why he thought the sizes were wrong. So I don't remember referencing anything beyond all the information that was contained in that. Now, whether that was combined by somebody else or not, I don't know. That's how it was provided.
Did you end up looking at the report of Ms. Gaffney and what had happened in the past with the download and search of Ms. Reed's Lexus materials?
If I'm remembering right again, I think Ms. Gaffney's report was also attached to that same singular file.
You learned that the defense expert, Ms. Gaffney, had downloaded data from chips, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
In that form, it's sustained.
It's
It's stricken.
My apologies. The conclusion Mr. Burgess had is that he believed there was missing information from the chips.
He did. He miscalculated the size of the chips.
Did you do any study to see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately realized what the error was. The data sheets specify a size in megabits or gigabits. And Mr. Burgess had written his report in the context of megabytes and gigabytes.
And then you asserted, or you took the position in your affidavit, that there should be no further chip off, no further study of those chips, other than to ensure the amount of memory was sufficient.
It's not how I recall specifically what I said.
Well, let me read it because I don't want to try to malign your words.
Please.
Mrs. Burgess proposed protocol labeled, "We attempt chip-off acquisition is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components."
That sounds accurate.
If you want to see this, I don't want to read from the document. If you need to see it actually, just let me know.
That's fine. I trust your reading.
However, an acquisition may be conducted for the sole purposes of ensuring the contents of the memory chips have not been altered since the last testing by recording the checksum.
Yes.
Did it cross your mind at that point that there was important data in those modules that was not seen or recovered or obtained by Ms. Gaffney?
No.
Did you want to know when Mr. Burgess was looking for more data, more information, what he thought was missing?
He stated, I think in his report or affidavit, I'm not sure what it was, but he stated what he thought was missing was there was a physical size difference. So he thought there was not corrupt data, but just missing chunks of data.
Log on information, you've heard of that. Ignition on, ignition off information,
Yes.
and infotainment system. That's important information when you're reconstructing an accident, isn't it?
It could be.
Well, you read information in this case. Pretty important in this case, wouldn't you say?
Yes.
And so you would not want to engage in that process without this pretty important information, would you?
Which process?
Of an accident reconstruction?
Sorry. So can you restate it, the whole question?
I'll
Yeah.
ask you again.
Yeah.
You said you have some experience in accident reconstructions.
Yes.
Don't you want all the data available? More data, the better?
Generally, yes.
You wouldn't want to ignore data on purpose, would you?
No.
I mean, the data analyst, the more data, the more you get to look at.
Yes.
And so the power log on information that actually has date and time, that's critical in an accident reconstruction, isn't it?
In some accident reconstructions, in some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and time that you can match with the text string data, correct?
Yes, it
As
does.
you know, text string data itself doesn't have date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
This had a running time instead. Like a
That's
stopwatch.
correct.
So this data that was not found during the initial process, that was critical data at the time.
I don't think prior to the process, anyone knew that this particular Lexus infotainment system stored those key on and key off times.
Right, the only person that found this out was Shannon Burgess.
He found it in the process, but I don't think anybody knew in advance of this case. There was nothing out there about it. So to my knowledge, this is the first time that this specific data has ever been released into the wild.
But it was on the board there, if someone knew what to look for or got creative, they could maybe find it.
Yes, more so to your if got creative, because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Sustained. I'll strike it.
And when Shannon Burgess went to obtain that data that everybody else overlooked or didn't know about, you went with him.
Yes,
So you had a process where he was going to now control the data and take the information that was left behind and remove it from the infotainment board, correct?
he actually never specified anything about the SD card in that initial notice. So it was a departure from his protocol, and it was a little surprising to me when I got there that the protocol was written with a specific focus on a number of other chips. And it became very apparent to me very quickly that the focus was not on those chips, and the focus was on this SD card that had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviations. So I was just surprised. It's not customary to sort of shift out of nowhere. But other than that, I did not know what to think of it because I'd never heard of that.
Did you give any input? Did you have any knowledge about the SD card and how it worked?
No.
So when you watched Mr. Burgess remove the SD card, did you appreciate he'd have to engage in what you call reverse engineering?
He did not elaborate to me exactly what his whole process was at first. It sort of came out as time progressed through the first day in his office in Texas And then I learned more as we moved to the second testing in Massachusetts. But he didn't explain it to me in one go.
Did you, at that point, understand or appreciate the relevance of the SD card relative to the infotainment system and what it could do as far as the amount of information that could then be available?
He never spoke throughout the 3 days at all about what kind of data he expected from the card or would be on the card or could be. He made no mention of the data.
Not what he said to you, but in your expertise, did it ever dawn on you the significance or importance of this SD card that was sitting in plain sight?
Objection.
Sustained, you can ask it to.
Did it ever dawn on you, as Mr. Burgess was recovering this information left behind, that there was something important or significant about it?
At the time, I thought it was a possibility. If you reference the initial work, a number of different memory components were identified in this infotainment. There isn't a singular memory chip. So if we're looking for data, it could be in any of them. So we found a new source of data storage, and there could be something there. There could be nothing there. It was unknown to me.
But it turned out there was.
There was.
Now, when you were watching Mr. Burgess work as an expert, if you felt like there was something inappropriate or he had some great oversight, you could write a report about that, couldn't you?
I could.
Did you ever write any report in this case?
No.
So you never wrote a report for your preparation of coming in and your data in the PowerPoint presentation, right?
Correct.
You never wrote a report regarding any of your observations of Mr. Burgess.
Correct.
You said that he didn't say anything. He spoke to you quite a bit during the process, didn't he?
He did.
He showed you what he was doing.
He did.
He explained to you what he was doing.
He explained the process. I think you had asked me earlier about whether he explained the data, and he didn't.
He demonstrated great proficiency, wouldn't you say?
He ended up with a successful acquisition of the card at the end of the process.
When you are considering all your equations, did you consider the timing information taken from the SD card that Mr. Burgess found regarding power on and power off of that car?
Yes, to the extent that he considered it in his own report. Again, I'm referencing his report.
But how about you? You're coming in here giving an opinion saying what's better or best practice or right. How about you? Did you consider, you personally, the one who's giving the opinions, did you consider the significance of the power on, power off data as it relates to all these times?
Yes.
Yes? Are you sure?
Yeah.
Okay.
I mean, I considered it. If that's the question is, did I consider it? I considered it.
Did you do any study yourself?
No.
Now, we agree, or you agree, that there are variances between different devices.
Yes.
So a Lexus clock that comes from the infotainment system is very common that it would be different than a different device like an iPhone.
Specifically this Lexus, I don't know if we can make the statement that it's common or not, because again, this is the only time that I know of that this specific data has been analyzed. So I don't know the answer to that question.
Did you say on direct examination that variances between devices are common?
Variance between devices are common.
In a variance of 45 seconds, that wouldn't be remarkable on
No.
different devices. It's common in the industry.
Correct.
And in your business, that's an accepted amount.
I'm not sure what you mean by accepted. The amounts are what they are, and we have to correct for them. I've done analyses of clocks that are anywhere from completely correct, 1 second off. I've done analyses of clocks that are 25 years apart. So it's a wide range of possibilities.
I understand your point.
Yeah.
If you see as an analyst a 45-second variance or 30-second variance, that wouldn't shock you, would it?
No amount of variance would shock me, is the answer.
I want to ask you questions and go through your PowerPoint. And I want to ask you your specific opinions and how you arrived at certain claims that you've made.
Sure.
Okay? If we could put up Mr. Disogra's new PowerPoint, 52525. You've made a modification to your PowerPoint.
Yes.
You've made an amendment to your PowerPoint.
Yes.
So there was something that happened. You received new information or new data, and you updated or changed your PowerPoint.
I did.
And that's an appropriate thing to do when you receive new information, isn't it?
Yes.
If you have new data, you don't want to leave it behind. You want to make the best presentation with the best data you can.
I'd want my presentation of the data to be as accurate as possible. So I included all the data.
And you would expect that from any expert, wouldn't you? If they received new information or analyzed new data and it was important, it would be an appropriate best practice to update the PowerPoint or information they're providing, wouldn't it?
Objection.
I'm going to allow that.
I don't know if I would tell other experts what their best practices are. I would say generally as experts, we do work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, then we don't do it.
Well, you like the phrase best practice on direct, so I'm just wondering if I can borrow that phrase.
Sustain.
Okay. We can turn to page 2. Now, this is taken from Dr. Welcher's report.
Yes.
And again, you did no testing whatsoever. You just read
I did
the report. Did you read all of Dr. Welcher's data, the gigabytes and gigabytes of data? Did you go through it all?
Not every slide, no.
Not just the PowerPoint. I mean the actual massive amount of data in his study. Did you go through the data?
Oh, no, I didn't look at any of the data.
Did you ever speak to Dr. Welcher?
No.
And so when you are making assumptions on what he thought or how he analyzed, you're just guessing.
I am looking at what Dr. Welcher put in his trial presentation, and my assumption that's baked in there is that he's going to stand behind the things he says in a presentation. So I'm taking them at face value, but as being correct.
It's not a matter
I'm
of
not guessing.
It's not a matter if he's going to stand behind it. You don't know why he put something in here. You just see it on the paper. You don't know what his thought process was, did you?
To an extent, yes, because I understand how the exemplar testing by Aperture laid the foundation to align the key-on events in the infotainment to the Lexus VCH events.
When Dr. Welcher made his PowerPoint, do you know whether or not he was relying on 154 on Mr. O'Keefe's phone, stamp 154, as the end of the event as opposed to the beginning of the three-point turn, 1162-1?
Based on the math he uses, that's the implication. He puts a number on the screen that the only way you could reach that number is by making that assumption. So when I looked at the math, yes, that assumption seems baked into the math he did.
So this seems like it's baked in that he was assuming 154 on John O'Keefe's phone was the end of the three-point turn.
Not on this slide, on a later slide, but yes.
Okay. And you said that variances, 30 seconds, 45 seconds, they're very common when you're comparing two different devices, right?
Yes.
Okay. Turn to the next page, please. You point out 2 times for the jury, the Lexus event 1162-2 ends 12:31:43, right?
Yes.
And that's based on the clock in the infotainment system.
That time is based on 2 things, the clock in the infotainment unit and the cumulative key-on timer in the text stream data. So it's a combination of 2 values.
Which is the running clock.
Correct.
Right. And that is compared or contrasted or coordinated with the log on off time that was found on the SD card. Yes?
Yes.
And without that SD card, we wouldn't have that time now, would we?
Correct.
Okay. 12:32:09 isn't something you analyzed, but you just read in the report that that is information from Ian Whiffen suggesting or taking the position that was the last user interaction John O'Keefe had with his cell phone, 12:32:09.
That's how I understand it. There was a phone lock at 12:32:09. I did not look into the underlying reports from where that came.
And you know those are 2 different devices, 2 different clocks that will have a variance.
Yes.
You mentioned trigger event, and you said that your preference is to, when you're doing times, to point it from the actual trigger event, and there was a little slap for emphasis to target you on that, right? The trigger event. That's not a standard practice or a protocol that is supported by any type of literature, is it?
It's the methodology I teach, especially in the class I teach on the analysis of heavy vehicle data. We have the exact same problem with heavy vehicles. They all have clocks on them. And so in fact, I do a lot of clock adjustment on heavy vehicles relative to other sources. And the way I teach it, the way I'm not the only instructor, collectively, the way we all teach it is we generally start the analysis at the trigger, which is not to suggest you have to do that. It's not wrong to do it a different way, but that would be let's call it the default methodology.
The default methodology, do you have any professional literature that says that is the best time to start the analysis?
Not literature. I mean, that's sort of my opinion, because that introduces the least amount of variables. Once you start trying to align events off of subsequent times, you just introduce more addition and subtraction or math you have to do. So it's easiest to do T0 and align everything from there.
If you're lining up the end of one event with the end of another event, it's more coordinated than if you take it from different spots, isn't it?
That could be a scenario where then you wouldn't use it. Right. Like I said, it's not the only way, but it's the default way.
I don't disrespect your method, but there are other ways to do it that are just as legitimate as the trigger knot.
Absolutely. And that's why I didn't change the convention here. I used their convention,
So you're
apertures.
not suggesting that Mr. Burgess was being misleading by choosing the endpoint when he pronounced that's exactly the point he was considering, are you?
No.
And so the word cherry picking, you're not saying he was cherry picking, are you?
I don't remember the context in which I used the word cherry picking, but I don't think it was with respect to a trigger alignment.
So there's no legitimate professional basis of suggesting your way is better or worse than going from the front or the end of the event?
No.
So you're not offering criticism on that, so just so I understand.
Not criticism. I pointed out that it's not typical, and I pointed out not even to say specifically that it's not typical, because even that, to your point, might sound critical. I just want to be clear that I adopted their convention. It's not the way I would have done it, but I kept that convention consistent in my analysis. So I wasn't changing in the middle, trying to obfuscate what I'm saying.
I appreciate that. So if someone's looking end to end, you're not going to add 5 seconds. It's if someone went from middle to end.
Could you give me that?
Yeah, you were
A little
suggesting
different.
those questions about, well, since you're looking at the end instead of the middle, then you got to add another 5 seconds on. That's not really an accurate analysis if you're looking at a comparison from end to end. You wouldn't then add the 5 seconds to the time to trigger because you're starting at the end from both devices.
Objection, Your Honor.
I'm going to allow it if you can answer it in that form.
It's going to depend on if you're doing an alignment with something that is a range of values, then you have to be consistent on where you're doing it. If you're doing discrete points, then that's just a single point in time. There's no beginning or end. It's just a single second. So the best answer I can kind of give is it depends on what you're doing.
Well, in this case, you're basing it off the end of the event, the end, not trigger, the end, comparing it comparatively to the end of different devices. So you wouldn't just add 5 seconds just for the heck of it.
You would not add 5 seconds for the heck of it.
You see 12:32:09 minus 12:31:43, the middle line equals 26 seconds. Isn't that in Dr. Welcher's slides before, let me phrase it more cleanly. Before Shannon Burgess analyzed the data more closely on May 8th, in his May 8th report, isn't this the exact difference in time that Dr. Welcher cites in his PowerPoint, 26 seconds?
I'll sustain it in there.
Did you see when you reviewed reports that Dr. Welcher uses this exact number plus 26 seconds in his report?
I got the number from the PowerPoint,
I'm sorry,
not the
PowerPoint.
report, but that is all of the numbers here on this slide are from Dr. Welcher's PowerPoint. And on the previous slide, I show that. So these are all just
And-
copied straight from that.
And you've labeled this John's interaction window.
I did.
Interaction window. Do you think it might be confusing when you use interaction window to make it seem like the event was limited to 10 seconds?
No, and that's not the implication there at all.
That's not what you're trying to say.
That's not what I'm trying to say.
Fair enough. Fair enough.
If I can clarify what I mean by interaction window is that there's
Please do.
a range of times that we end up with when we start running these adjustments. So we never land on a singular point of alignment. We end up, like I showed at the end, with 30 points. That's the window that I'm talking about. That's the window that I mean.
So if we could put up page 33 from Dr. Welcher's PowerPoint, just to illustrate what you're trying to help us with. Line that a little for me. So this represents, you've seen this, right?
It looks familiar, like it's from one of his slides. And if I've seen it, I did not spend a lot of time digging into it.
Does this look like the 10 seconds of data that would be captured from a triggering event in a text stream data? Judging.
I want to see you at Sidebar.
Oh, the mute didn't come off. That's what, 7? Sidebar 7? And the jury is, oh, what did he say to the jury? Oh, actually, hold on. I don't get it. It's 7, but why are we getting the fan for a sidebar? Usually we get the chairs. Yeah, he was a great defense attorney. You know, people have been saying, wait till you see him on cross, but I didn't believe it until he came out swinging. Do you realize he dismantled the whole defense's direct in 2 questions? In 2 questions. Right to the heart of the matter. Boom. You're not saying. Nope, I'm not. I'm like, what? Oh, is it 7? Did I say 8? No, I said 7. Okay. 48 minutes. Maggie, is that what you heard? 48 minutes? Don't scare me like that. You were right last time. And you heard what I didn't. She does not look well the last couple of weeks at all. I agree with you, Mandy. I think the stress is really and the pressure has really gotten to her. It has to be an enormous amount of pressure for years of this to be on. And just the fact that we're now coming towards the final part of the second trial, it has to be. I said 700. Very funny, Purple. Maybe I did. It feels like it sometimes. I could have. Well, Mandy, you're right. She doesn't look well at all. I think it's the pressure. I think she feels like she has to control the situation. She's acting out a little bit. She's even with her own support team. Oh, it took 48 minutes to get to this sidebar. Oh, I see. Yes, and we have 10 minutes to 1. It does feel like 700, Mandy, sometimes. Well, somebody posted on the socials that the plow driver is in the courthouse out there in the waiting area. I wonder if he's the next witness. Well, true, because that's exactly what he was hired to do, right, Turtle? Turtle. He was hired to just look at the data and tear it apart. I don't know. All right. It's moving. It's moving. Is it coming down? It's slowly. Boy, this is the slow-mo, huh? The slow-mo pan of the paneling. Very dramatic. To the empty seats. To Mr. Wolf just watching the sidebar, wondering what's going on up there. I don't think so, Maggie. I don't think that the plowman. He is going to say that he did not see a body. Which, if he was plowing in his vehicle, well, I can imagine he didn't. Not to say it was there or not there, but that is their evidence that he wasn't there, that he was in the house getting beat up. Did he? Is he the same plow driver? Is that true, Mandy? Is that what he testified to in the first trial? That he hit a standing basketball hoop? Wow. He pays a lot of attention, does he? Yeah. It's going to be interesting. All right. Oh. Don't spill water on the papers, dude. Why does Jackson seem flustered? Is he coming up on read? Is he going to do redirect?
So jurors, we're going to release you for the luncheon break. I took so long here to make sure that we could give you a nice full hour luncheon break. So we'll see you back here in an hour.
Please rise to the jury.
Okay, but I don't think that was the end of Hank's question. Cross, was it? Did he say that was the end? If he did say it, I missed it because I was just celebrating his questions and didn't hear the end. But we're gonna go to lunch then, which means we're gonna have to start that second stream. Okay, she's leaving. That's it. We're going to lunch. Okay. Oh, Maggie, good. I'm glad somebody's paying attention because I don't know why I'm not hearing the last thing that happens besides sidebar. It's like the last couple of minutes just go pop right out of my head. I think I have trial fatigue. It's a thing. It's a thing that happens with me. It's just like, but that was a very, I'm all down with the cross so far. I actually thought the defense, I think he tried to make some points, Yeah, I think we're going to lunch, everybody. I think we'll go to lunch. What do you think? Shall we go take a break? And then we'll come back and see what else Hank has for us this afternoon in the defense. I'm very curious about their witness list because, so far they've been really pushed by the Commonwealth in regards to ARCA, in regards to the Proctor texts. And they really are trying to get this third party culprit in front of the jury to give an alternate theory to what happened so that they disregard the evidence that the Commonwealth is putting forward. And remember, they don't even have to present a case. So it doesn't mean they need solid evidence. But here's the thing. In order to enter third-party culprit, Judge Cannone's ruling was you have to have evidence of it before you can do it. You have to have something to link it to. You can't just talk about it. And so they're going to have to put something of some nature on the stand or enter into evidence. And they did that with the Brian Higgins text in cross-examination. Yes. So there you go. Yep, we're gonna go to lunch. So everybody enjoy your break. I'm gonna go make some coffee and go snuggle my dog, give him a good stretch of his legs. I'll see you back here with the second stream. Let me pull that second stream up while I'm thinking of it and give you the link for YouTube. Those of you that are watching in Twitch, it will just automatically pop back up for you. So you don't have to really go anywhere. You can just leave the chat up and it'll come back. And just on another note, those of you that follow some of my other cases, I will be doing a P. Diddy review tonight at 9:00 Eastern time too. All right. Let me put this. I'll put the link in the for YouTube in the YouTube chat, since Twitch is going to come up automatically. There you go. Hopefully I'll see you all this afternoon after the break. Take a nice good one, get a stretch of the legs, and I'll be talking to you again real soon. Thank you so much for hanging with me this morning.